My lord, I have got some difficulty. My lord, my adversary is Mr. Billodal Bhattacharya. But I have taken his consent. Your lordship, my lord, fix it on some other day, my lord, in the first week of August, my lord.
Okay, the junior will be there.
Yes, yes. Mr. Dasgupta will be there, my lord.
You inform Mr. Milad?
Yes, yes.
Okay.
I have spoken to him. He has consented.
In his presence, and I will.
Well, I'm
My
getting.
lord, only one humble prayer, my lord. The SR matter, my lord. Only one humble prayer. The petitioner is the 75 years old. My lord, he cannot go in the out of India for his treatment. He is a kidney attack patient, my lord. He is a humble prayer, my lord. Any day, any time, my lord.
आज 1 बजे रख दो SIR के साथ.
Lordship,
टुडे SIR के साथ 1 बजे रख दो सप्लीमेंट्री में.
Lordship, I mentioned about this. This is that army invocation matter. Your Lordship had allowed that this matter appear on 22nd of July. It was appearing in serial number 19. Now, Your Lordship, yesterday, so 22nd was Wednesday. Yesterday it became item 33. Today it's 43, Your Lordship. And I had 18, 19 both on Wednesday. 18 got taken up as item 8 yesterday, Your Lordship. And 19 becomes 43. So Your Lordship will kindly help me out with this, Your Lordship. Because this is the summary of evidence proceedings are going on and he needs to appear, the petitioner. So Your Lordship, item number 43 of today's list.
Okay, see today what happened, then I will see to that. Let's
I'm
continue.
grateful. I'm obliged.
My lordship, may I have a kind leave to mention?
Under complex circumstances, I am mentioning one matter, my lord. Today is item number 30, my lord. This matter relating to Assisted Productive Technology Act covered by your judgment. Here, this matter was heard on 10th June. As state was not represented, your lordship directed serve the notice that matter was fixed on 30th July. On that day, matter appeared as item number 141. Thereafter, on mentioning, your lordship indicated in the mentioning slip that yesterday, 23rd, within 10. Yesterday, item number 18. Today is item number 13. It is covered by your lordship judgment.
Item number
30. Today is item number 30.
So what you want?
It is covered by your.
Like this, you only every day. If the 10 persons is mentioning, so it will then automatically it will go down. Only the I have fixed 2 days mentioning, but you persons are not going by the cause list. You are mentioning every day. The same, then you have to face the consequences. Either you go by the cause list which I have given, then your list, your serial number will maintain. If you will say that every day you will mention, then the same consequence has to follow.
Fair and proper.
Okay, yes.
May I have a kind leave to mention two matters?
There is no mentioning. Yes, call the list.
Application. My lord, leave application.
At the time of rising of the court, interim order will be taken.
My lord, leave application, my lord.
Yes, so is the number 1.
I am for the petitioner.
Yes.
Is that matter, my lord, documents are required to be, my lord, released and produced before this court for.
Yes, madam.
My lord, all the original documents and compliance report.
You do one thing, you both sit, check the document, come at 1. Before taking other matters, come at 1. If it is ready, I will dispose of. Next.
But my application, the DVC had served us with a report.
My lord, this is the report, my lord, which my lord has desired, my lord. On the last occasion during the in course of the hearing, my lord, of the application, my lord was pleased to observe that, my lord, the tenders are different. The BOQs containing the price is also different. And also, my lord, the phase 1 is mentioned in one of the tenders and the phase 1 is not mentioned in the other tender. My lord will kindly seize, my lord. There is also a schedule, my lord, which we have prepared pursuant to my lord's kind direction, my lord. I am led by Mr. Shobhashasi Chaudhary, my lord, on this matter. My lord, page 53, if my lord kindly sees, my lord. There is a diagram, my lord, which has been made, my lord, pursuant to my lord's kind direction, my lord. Where, my lord, the red earmarks, my lord, are the project, the site where the writ petitioner previously was conducting the entire project work. My lord, this particular petition before my lord is the existing colony building, my lord, which is at the bottom, my lord. If my lord kindly sees, my lord, there's a road in between, there's a thin, narrow road, my lord. It is in this map only, it is thin narrow, but it is a big road. Thereafter, my lord, there's an existing colony, my lord, which is the site in concerning this writ petition, my lord. So, my lord, I have taken specific instructions from my clients, my lord, inquiry, my lord. This project has no concerning the tenders. My lord, the petitioners, I may respectfully submit with my lord, the intention, my lord, is to stall the entire project throughout the radius of this particular entire site. My lord, the project, the site which was before the arbitrator and which is in the arbitration, my lord, is completely different from the site, my lord, here. My lord, this pictorial diagram, my lord, once again, if I may refer to it, my lord, the existing colony building at the bottom of the entire project site, which is the entire project for this particular tender, my lord, which is in,
Where is the existing?
my lord, at the bottom. My lord, if you kindly see, there's other side of the road. My lord, there's a narrow road, my lord, in other side of the road. This is the existing colony building. It's in written, my lord, it's big alphabets, my lord. This is the particular site, my lord, wherein, my lord, the carried on. My lord, thereafter, my lord, there's also a Google Maps outlet. My lord, Mr. Chaudhary is there, my lord.
Lordship will have a look at the map, my lord, at page 54. That what has been described as the new colony and old colony, the subject matter of my learned friend's contract, which is also the subject matter of an arbitration proceeding. That is, my lord, so far as the that is new colony, the larger portion. And what is being done here is, my lord, a CISF quarter. Quantum, my lord, Lordship has already noticed the quantum value is also much less. It is 14 lakhs and not the BOQ quantities that is there. And the subject matter of their contract was in excess of 30 crores, 33 crores. So, my lord, it is completely different. And, my lord, in between there is a road. If Lordship takes the sketch map, I believe my learned junior has already shown to your Lordship.
Yes.
That after Lordship will find, my lord, there is an entrance towards the bottom half of the diagram, entrance, and then there is a main road. Let the main road, my lord, Lordship will find existing colony building is on the left hand side. If Lordship looks at it in a portrait formation. And, my lord, the ones in the red are what the subject matter of the contract of the petitioner. So, my lord, it's completely different. And, my lord, on oath, my lord, kindly see, this has been on oath, the assistant manager law has affirmed it, saying this, and they are protected by already an order in the arbitration proceeding. And in case, my lord, there cannot be any, not that we are violating or anything of that sort. It's a case of mistaken identity. I don't want to say anything. They were apprehensive because I believe the title was misleading, because it was saying, my lord, colony. The title was misleading, colony, and they without going into the BOQ quantities are completely different.
Yeah.
And the subject matter of their contract is already the subject matter of an arbitration. If anything, they can always go there. But I can assure your Lordship, this has nothing to do with the subject matter of that.
Yes.
Yes, sir. May I just show your Lordship how your Lordship is complex, your Lordship is situated. Well, Lordship, this is the entrance gate. Now, your Lordship, right hand side, your Lordship, the portion, your Lordship, is the existing one, and the left hand side portion, your Lordship, is the construction we have made. But your Lordship, the entry gate is same, CISF complex. Now, your Lordship, background, your Lordship knows. Now, in this particular matter, your Lordship, we have been given regarding the civil as well as the, your Lordship, electrical work. I don't want your Lordship the unnecessary delay in the matter. Lordship, we don't want your Lordship to delay regarding their contract. What we are apprehending, if your Lordship kindly takes your Lordship the tender, why we are so apprehensive? Lordship, kindly take volume number 8. Volume 8. So kindly take page 1092. 1092.
9.
1092, your Lordship.
Yes.
Lordship, this is the, your Lordship, the fresh tender of 14 lakhs, your Lordship, which he has The money factor, your lordship, is not very important. Lordship, kindly take page 1117.
Yes.
Lordship, kindly take clause number 3.0.
Yes.
Work site, your lordship, inside the tender is shown as DVC RTPS civil. So we don't know, your lordship, whether this will be used, your lordship, is in the right side or the left hand side. We don't know. Now, after this particular tender, your lordship has granted an order to show whether the BOQs are same or not. Your lordship, kindly sees the last order. The site was in first day, your lordship, the site was not in dispute. The dispute was the scope of the work. Lordship, kindly sees the last order of 20th of July 2026.
Yes.
Paragraph 5. Para 5, though there is a dispute with regard to whether the work which was the subject matter of the earlier tender and now the proceeding is pending before the learned arbitrator and the present work which is in which the respondent authorities have issued the tender are similar. The respondent authorities are directed to file a short affidavit giving the schedule of both the work to justify whether the work of the earlier tender and the work of the present tender is different from each other. Now they have given the report. Lordship, kindly take the report. Lordship, page number 5 of the report.
Yes.
Page number 5 of the report, your lordship, is the BOQ in connection with the present tender.
Yes.
Now, lordship, kindly sees first item, providing and laying autoclavated aerated concrete AAC blocks machinery. This particular tender never written, your lordship, that this is for repairing and maintenance. Regarding the tender, your lordship will have seen the entirety. Your lordship will not get it. This is for a fresh construction. Now, left hand side serial number, I can match, your lordship, entirety with the balance BOQ. First is matching with 2320. Second one is matching with 510. Third is matching with 520. If your lordship kindly matches with this, they are the given. Lordship can see 2320. Lordship, kindly take page 29.
29 of the
Same report.
See, Mr. Dasgupta,
Yes, sir.
once they have given the map, and map, they have specifically provided your work, which is before the arbitrator, is totally different, and the existing colony building is the different one. That is total opposite of the work which has been awarded to you, which is the subject matter of the arbitration.
Lordship.
So now further what remains?
I know, your lordship. Because the tender, your lordship, why we have come before the honorable court, your lordship, that was a bona fide act.
Correct.
Now, your lordship, they have come.
Yes.
Only protect me, your lordship, to that extent that this particular tender, your lordship, will not
But
apply.
now this map is on record with the affidavit.
Lordship.
By relying upon this, the court is relying upon this map as well as the statement made in paragraph 5. No, 5. Did the paragraph 5? Read the paragraph 5.
No, for 5, your lordship, is regarding the balance work.
Correct.
And
No, the township including CISF concrete RTPS being subject matter of the present item was not the part of the works to be aggregated by the writ petitioner and is not also not the part of the balance work.
exactly. I have covered by that.
Correct.
Only one thing, paragraph 3, your lordship, second line.
Hmm.
There are two things, your lordship.
Hmm.
The subject matter of the present writ petition relates to a tender issued by the respondent pertaining to the repair and maintenance work
Correct.
of the existing township.
Correct.
What I am on, your lordship, the joint measurement, your lordship, is likely to be finished.
Correct.
Now, I only want, your lordship, kindly restrict them only not to, your lordship, enter with my project inside, nothing else.
How they kindly see, kindly come to the page 53
Yes, sir.
and 54.
Yes, your lordship.
Correct. 53, the red mark is the your work awarded to you.
Yes,
Work
sir.
awarded to you.
Lord.
53, there are 4 red marks.
Yes, sir.
1, 2, 3, 4 red mark. Correct. That is the work awarded to you, which is the subject matter before the arbitrator, and
Lord.
that is to be inspected or surveyed by the special officer, whether it is completed, incompleted, whatever it may be. Now the work which has been awarded the existing colony, the just opposite.
Lordship,
So it-
existing colony have not been given it to me.
No,
It's the new one has been
that's why
given.
they are telling the existing colony is the present work.
Lordship, kindly record their
I
submissions.
will record because
Yes, your Lordship, kindly record
It's
their
on
sub-
oath, the Lordship can record the affidavit,
It
my
is
para 5 can't be more
Yes,
clear.
yes, your Lordship, kindly record their submissions so that your Lordship, then this
And-
particular thing, your
and
Lordship, will-
that is more clear. Kindly come to the Google map of 54.
Google map, your Lordship, I have seen the Google map, old one, new one. These are never the part of the tender. Otherwise, I would not come up before the Honorable Court.
Correct.
There is no necessity to come before the Honorable Court.
So I am clarifying here.
Yes, your Lordship. And
Sufficient-
kindly one line observation, your Lordship, these things are going on continuously. Till your Lordship, this joint measurement is
My
completed.
learned friend can't say because he is litigating, I will not do any work.
No, you do any work. You do whatever
And
you
it
want.
will be in RTPS. It's a thermal power station.
Yes.
And in future, what will happen? This court cannot say.
No
anything
problem.
here.
We shall-
You cannot.
We have to be little vigilant about DVC.
That's
We'll do it.
correct.
Lot.
That's correct.
Same
In terms
amount
of the
of
order
vigilance
passed by
by
this
the
court dated
Yes,
20th
yes.
July
Your clients are
2026,
always.
comma,
My clients are
the
always.
respondent authorities have filed an affidavit, filed a report by way of an affidavit. Respondent number 1, respondent number 1 filed a report in the form of affidavit stating that paragraph 3 and paragraph 5. From the affidavit, in the affidavit, it is categorically mentioned by the respondent number 1 that the work awarded to the petitioner, which is the subject matter of the arbitration, is not the similar work of the present tender document, tender proceeding. The respondent number 1 has also disclosed the schedule, the map being X3 at page 53 of the report, wherein the respondent authorities have clarified that the work awarded to the petitioner, which is not subject matter of the arbitration, is marked in with the red ink, and the existing work and the work of the present tender process is recorded as the existing colony building. That is totally opposite to the work awarded to the petitioner, which is not subject matter of the arbitration. The respondent number 1 has also disclosed the Google map being X4 at page 54 of the affidavit. In the said Google map also, they have clarified that the new colony portion work was awarded to the petitioner, and the old colony portion is the work of the present tender. From the statement made by the respondent number 1 and the sketch map as well as the Google map, it is mentioned that the work awarded to the petitioner is totally different of the work of the present tender. Considering the above, this court find that the petitioner and that the work of the present tender is not affected with the work of the petitioner, which is the subject matter of this arbitration proceeding. Accordingly, the report be kept with the record, and this court find that no further order can be passed in the present date application. Interim order is stand vacated. The respondents are free to proceed with the tender process in accordance with law.
The writ petition may be disposed of.
Disposed. Next.
Lord, I appear for the respondent number 123, Lord.
Who is for the petitioner?
Mr. Private respondent.
Oh. Lord, kindly allow me to appear, Lord, virtually. Or
Yes.
if my Lord keeps it at 2 p.m., I can come physically and do it, Lord.
No.
At 2 p.m. Lord, I will not be there.
No problem. Now continue. I have no problem. You can.
As your Lord, sir. As your Lord, please, Lord. Lord, my junior is there with the instructions from the authorities. We have
Yes.
got it, Lord. It's there.
Lord, kindly turn to page 24.
Yes.
This is the Lord notice inviting tender. The first supply of medical gases in cylinders having capability to supply of all medical gases, namely medical oxygen, is important. Underline this. Medical nitrous oxide and carbon dioxide for a zone A, zone B, zone C. Therefore, the basic material for supply would be medical oxygen, medical nitrous oxide. Now, kindly turn to next page, the eligibility criteria.
Yes.
The bidder should, paragraph 2 of eligibility criteria, the bidder should have the capability to supply all three gases: medical oxygen, medical nitrous oxide, and carbon dioxide. Then, Lordship may come to clause 4. Bidders should have minimum stock of 4,000 B-type and 4,000 D-type cylinders inventory with him, and all cylinders should be approved by PSO for handling medical oxygen IP. Now, will you kindly turn to next page, page 26. What are the basic requirements of eligibility? Zone B. B-type 1500 numbers of medical oxygen cylinder. At the top of the column, you also find medical oxygen cylinder. They have the capacity of B-type 1500 cylinders, A-type 400 cylinders. And medical nitrous oxide, A-type 200 number of cylinders. Now, straightway kindly come to me at page 133. This is the application filed by them showing their eligibility, which directly hits me out the clause.
Page 133.
133.
Yes.
133 দেখাচ্ছি তারপর 130 দেখাবো kindly count will at 133.
Yes.
My lord will be pleased to notice that their capability, he declared that the stock position of oxygen cylinders which they show does not tally with the requirement as per Milord.
Who has given this?
This is the Milord, my private respondent, who has allegedly been Milord selected as L1. I am the L2.
Okay.
And then turn Milord, page 130. This is also very important.
So 133, A-type 300.
Yes.
And here is the A-type is 400.
And B-type also, Milord?
B-type 1600.
The requirement is of 4,000. Now, kindly turn to me, the more important thing is at page 130, that this is the certificate issued by the appropriate authority in favor of MTC. Well, I don't know whether my lord should be able to read. The font is so small, I couldn't read, but
Yes.
I have prepared a better copy for your lordship. Subject is, the certificate is given for examination and testing of nitrogen, oxygen, seamless cylinders. The medical oxygen was most important, but the item is missing. Therefore, they don't have the qualification. But we raised this issue, my lord, before technical bid period. Ignored.
and they have been given, my lord, the benefit of L1 and L2. Work order has not yet been issued. Therefore, my lord, a person who is not basically eligible, how come, my lord, the authority consider his offer and select him as L1? That will be the basic question, my lord. I will not take much time.
Yes. That's all. Yes. Who is for the
Lord,
state?
Lord, I appear, Lord. Lord,
Yes.
kindly take the technical qualification eligibility which is required. Lord, at page 25, the eligibility criteria. Lord, I just give you, Lord, see 3 dates, kindly mark those dates. Lord, the tender was floated on 5th March 2026. Lord, 5th March 2026.
Yes.
Lord, on 27th May 2026, we issued the first shortfall notice.
First?
First shortfall notice to all the bidders, whoever there was a shortfall. The second shortfall notice was issued on 4th June 2026. Sorry, 9th June 2026.
Yes.
9th June 26. Mr. Bhattacharya's client lodged a complaint on 8th June 2026. 8th June, can you mark the date, Lord?
Yes.
Technical bid open on 16th July. In the technical bid, Mr. Bhattacharya's client and Mr. Sen's client, both of them qualified. Mr. Bhattacharya did not come to court, did not raise all these issues at that time. He waited for the financial bid to come. 20th July, the financial bid is opened. When he found that he has lost in the financial bid, this writ petition has been filed overnight. So my first point is that he was sitting on the fence and watching. He took a calculated risk before coming to court. If the private respondent was ineligible, he could have not challenged it on either on 8th June when he pointed out, or on 16th July when we found the private respondent to be technically qualified. So a person who has took a calculated risk, he cannot now be allowed to, at this stage, after the financial bid he has lost, to come and challenge it. This is my first ground. Now, kindly take up the report filed by us, my lord. Kindly hand it over. My junior will hand it over to your lordship, my lord. Lord, this is a communication, my lord, with court, my lord. These are all documents, my lord. Lord, kindly take one document only. Kindly take the report once, my lord.
Yes.
Lord, in the report, your lordship will find a resolution dated 30th June 2026, Annexure 4, IV. Lord, I don't think it is page marked, not paginated. Kindly excuse me. Lord, the gentleman has prepared it not overnight. At 4 a.m. he sent it to me. 4 a.m. in the morning he sent it to me. Kindly look at Annexure 4, the resolution of the tender committee.
Yes.
Lord, the resolution of the tender committee is before your lordships. Lord, kindly have a look at it. We have considered all the documents submitted by all bidders, the shortfall documents, Lord, the documents that Mr. Bhattacharya's client has submitted. Mr. Bhattacharya's client is Geeta Oxygen, serial number 3 at internal page 2. Serial number 3, internal page 2. And Mr. Sen's client is Lord, serial number 6 at internal page 3.
Yes.
Lord, tender committee in their wisdom applying their Lord adjudicatory process, Lord, has taken all documents into consideration and found them to be technically qualified. Now, Lord, this is a resolution of the tender committee. Now, kindly take the technically qualifying criteria once. Eligibility criteria in the writ petition at page 25, where Mr. Bhattacharya has shown.
Yes.
Lord, kindly have a look at what is his case. He says that at paragraph 3, the bidder must be manufacturer of bulk filler of either medical oxygen IP 2022 or medical nitrous oxide IP 2022, or bulk filler should have the necessary tie-ups with the gas manufacturers to be able to supply the gases as per requirement.
Bhattacharya has relied upon 2 and 4.
2 and 4, very well. Lord, 2. The bidder should have the capability to supply all three gases: medical oxygen, medical nitrous oxide, and carbon dioxide.
Yes.
This is his. He says that Mr. Sen's client is not eligible. Then he refers to clause 5. What is clause 5?
Clause 4.
Clause 4. Clause 4, bidder should have minimum stock of 4,000 B type and 4,000 D type cylinders
Correct.
inventory with him and all cylinders should be approved by PESO for handling medical oxygen. And then 5, the bidder should be competent enough to deal with the business of supplying medical gases to the hospitals and health centers for which the bid is being made, and should have adequate financial capability of manpower, skilled, semi-skilled, unskilled, required for managing the business awarded as per A1 below. Now, what is A1? But he has applied for zone B and zone F. No, and the private respondent has applied for all the 6 zones. The tender was floated for all 6 zones. Mr. Bhattacharya's client applied for B and F. Now he referred about B, kindly sees B. What is required at the top? 100% government cylinders should be filled by the bidder, but the bidder should have the sufficient stock of cylinders and cylinders to replace the damaged defective government cylinders during refilling of the additional requirement if any exigency. B type cylinders 10 liter water capacity, A type cylinder 5 liter, D type bulk cylinder 47 liters, excluding all medical colleges and hospitals. So according to this, the bidder should have sufficient stock. He says that Mr. Sen's client doesn't have the stock. Now, while giving him the tender, what are the documents that need to be filed by him? Kindly take page 28.
The only short question is here. Kindly come to the zone B. Mr. Bhattacharya is only restricted to zone B. Now, kindly come to the B. Hospital of BPHCs in the district of Uttar Dinajpur. So, with regard to medical oxygen cylinder of 2020, D type is 1500 and A type is 400. Correct.
Yes, and for medical nitrous, it is for medical oxygen. Nitroxide is 215, and for carbon dioxide, it is 2 kg cylinder. Correct. He says that the private respondent number 6 doesn't have that stock with him.
Correct. That is the only.
Now, kindly come to now while evaluating a tender. We have given.
Please come to 133, page 133.
My lord, kindly take 133.
Whether this is the document submitted by the private respondent. And you are relying upon this document, then you have to justify how you with regard to the B zone it is fulfilled. That's all. Then the court nothing to go by on other things.
Lord, unfortunately, subject to correction, this particular point is not taken in the writ petition, in the pleadings. It is being argued. They have annexed it. It is being argued. It is their case that Annex P7. Kindly take the pleading once. Annex P7. Annex P7. Kindly take the pleading once. Kindly take Annex P7, the pleading once.
Yes, paragraph 12.
Paragraph 12. Kindly have a look at it. But what they are saying is that under Rule 43 of the gas cylinders rule, no person is permitted to fill any cylinder with the compressed gas, process cylinder filled with compressed gas, except in accordance with the conditions of the license. Statutory mandate is one, strict compliance of the license actually granted and not with a license which is assumed to implied or treated equivalent to the administration. It is further stated, bare perusal of the permission issued by the competent authority to the petitioner that the respondent shall clarify difference as much as the petitioner has specific permission to test and store the required medical gases. He relied on 130. 130 is the document, that is the license that the respondents have produced before us.
Correct.
That license is valid till 2026.
Correct.
Lord, kindly take my report one more time. Kindly take the report that you have filed one more time.
Paragraph 14 is the basic pleading.
Yes, kindly take my report one more time, Lord.
Now, kindly come to the page for paragraph 14.
Paragraph 14, my lord, paragraph 14. Just give me a second. Paragraph 12, paragraph 14. your petitioner states that the respondent number 6 also failed to satisfy the minimum installed capacity prescribed under clause 4 and 5 annexed in notice inviting to self-declaring declaration submitted by the respondent itself demonstrate that respondent number 6 does not possess the installed production capacity. It talked about the production capacity. But kindly appreciates the tender document wanted, page 28 is the document that needs to be filed. Kindly have a look at 28.
Page?
The page 28, the document that those are required to be filed. Leakage or page 28.
Yes.
Lord, as per technical bid requirement, this is the document that not to be submitted by the tenderer or intending bidder at the time of applying for the tender. Lord, that these documents have been submitted. There was no shortfall in the submitted documents.
So that's
And
why, Mr. I only
Dr.
asked the one question whether you have relied upon 133 or not. If you're not relied upon
that
133 and 133 is consonance with the page 27, 26, then the Bhattacharya case is not there. If you say no, you have relied upon 133 and it is not in consonance with the page 26, then your decision is wrong. This is the only two things is to be taken
Lord,
into
page
consideration.
133. Page 133. Lord,
You have to your tender process in accordance with your requirement. So the only question Mr. Bhattacharya raised with regard to the zone B, this type and page 133, you give the answer whether this is the correct certificate which you have taken into consideration or the Bhattacharya has not placed the document which the private respondent placed before you.
Lord, Mr. Sen can clarify. Lord, right now I don't have the instruction. The litigant is there in court. I can take that instruction.
Yes.
I'll explain that.
Yes, tell me whether the 133 is your document.
But kindly read clause 5. My learned friend has placed only clause 4. But clause 5 and the table is very important.
Yes.
So kindly see what clause 5 says. Bidder, clause 4 is the stock.
Correct.
Clause 5 is my competence.
Correct.
Bidder should be competent enough to deal with the business of supplying medical gases to the hospital for which the bid is being made. And competency is to be determined on the basis of the table, the requirement.
Correct.
What is the requirement? Kindly see for zone
No,
B.
see, clause 5 says the bidder should be competent enough to deal with the business of supplying medical gases to the hospital and health center for which the bid is being made and should have adequate financial capacity. Financial is, there is no problem here. And the manpower skill. This is the manpower financial. Now they come to the table A.
Kindly, yes, table A1.
Yes.
Distribution minimum capability of the bidder. Zone B is a consideration. Now under zone B, for medical oxygen cylinder, kindly see what is my competence test. B type 1500. I will have to supply B type 1500.
Correct.
A type 4, D type 1000.
Correct.
Now kindly take that document. 133.
Yes.
E type I have 1600. At page 133.
B type?
B type 1600 for oxygen cylinder.
Okay.
Requirement is 1500.
Yes.
D type is 2100. Requirement is 1000.
No. B type is 1500. You are having 1600.
Right.
Okay, no problem. Then A type. A type. Then A type.
Huh?
A type.
A type is 300.
400. 400. A type is 400.
For 400, this
You are having the A type is 300.
300. Now D type is 2100.
Yes.
Requirement is 1000.
Which one?
D.
D type.
Yes.
Yes. 2100.
Yes.
Yes. You are having the 2100. Requirement is 100,000.
1000.
Yes. No problem.
So, now, therefore, your lordship will consider which clause, even for nitrous oxide, D type, everything is given.
Correct.
So, the question is today, the tendering authority has considered my competence based on this declaration. According to them, if they have taken a decision my lord, that clause 5 prevails over clause 4. Because more than stock, my ability to supply is a much more important requirement which I should fulfill.
No, but the question is that once the authority has fixed a specific criteria, whether there is any reason recorded that this has been exempted to you to decrease the quantity.
It is, but there is no
So-
exemption.
So why? So there is no necessity for giving the capacity.
No, clause 5 I am saying, clause 5 is more important than clause 4.
Maybe,
If clause 5 is considered, my lord, there is no violation.
sir, here clause 5, 4 with regard to the stock.
Yes.
There's no problem at all. Correct.
Yes.
But clause 5 says you have to show this,
But
of this. If you're not showing this, if you're not having the 400 in A type and you are having a 300, how the other party who is having the 300, so what is the specialty to avoid the contact to you? What is the specialty?
The question is, my lord, it is to be seen on an overall consideration.
It is not the condition. Show me the condition overall is to be taken into consideration. Why A, B, C has been categorized?
Well, your lordship will kindly see, it is for medical, there are 3 types of gases. which are
Correct.
present. So, my lord, they have considered it in cumulatively.
Correct.
So, my lord, today, my lord, I'll just show your lordship only one thing. My lord, there is a particular decision which is taken. If they have to show that taxation, if at all given, it is malified. But there is the tendering authority has this much amount of discretion for
Show me.
some relaxation.
Show me.
But
Show me the tender authorities have a discretion to accept the lowest if you are not having the capacity of 100 now and A type 400 numbers.
but I'll
If see this tender is for the
Yes, but-
competition.
yes.
It is not only you two have participated, there are 8 persons have participated. Out of it, and Mr. Bhattacharya's client has participated in zone B. And because he shows that he is having the capacity of zone B only. And you have participated in all.
I participated zone, yes.
Correct.
Zone
You
F
have
also.
Correct. You have participated in, as per the Mr. Government advocate appearing for the government, he stated that.
Yes.
Now, so zone A, zone B, zone C, the particular has given the requirement is given separately. So authority has to go by the particular given in the tender document. If suppose, leave aside you or other thing, if a normal person is having less than 100, whether the authority will accept, no, he is not having the 400 capacity, only having 300 capacity, that's why they are rejecting. So what is the reason for appointing you? We are not having the capacity of 400, you are only having a 300.
But my only submission is, well, this much amount of relaxation, this is within their authority.
Okay.
Unless it is accentuated by malafide. But there is no.
Even the authority find that the other bidder is having the maximum capacity which provided in the contract. I can accept your submission. If yes, all the bidders are having only 350, 300, okay, then the authority will say, instead of going for the tender, we'll accept. But if the authority find that the other bidder having the capacity of that quantity, so what is the reason for rejecting the capacity, having the bidder, the quantity, or allowing the persons who is not having the prescribed quantity?
But your lordship will just only kindly take one judgment in this regard.
So,
kindly take 2023-19 SCC, page 1. Okay.
yes.
Kindly take paragraph 50.
50?
Yes, at page 18. Tacitum D, my lord. This court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrary malafide or bias or irrationality is made out. One must remember today that many public sector undertakings compete with the private industry. Contracts entered into between private parties are not subject to scrutiny under writ jurisdiction. No doubt the bodies which are state within the minimum Article 12 are bound to act fairly and amenable to writ jurisdiction, but this discretionary power must be exercised with a great deal of restraint and caution. The courts must realize their limitations and the havoc which needless interference in commercial matters can cause. In contracts involving technical issues, the court should be even more reluctant because most of us in judges' robes do not have the necessary expertise to adjudicate it upon technical issues beyond our domain. The courts should not use a magnifying glass while scanning the tenders and make every small mistake appear like a big blunder. Courts must give fair play in the joints to the government and public sector undertakings in the matter of contracts. Court must not interfere with interference will cause that is then kindly see paragraph 55. Then paragraph 52 where Ronak is quoted, my lord.
Yes.
27 of that Ronak in the present case.
Yes.
However, the relaxation was permissible under the terms of the tender. Relaxation which the board has granted is on valid principles looking at the expertise of the tenderer and its past experience. Although it does not exactly tally with the prescribed criteria. It does not tally.
But the first permissible under the tender
Well,
contract.
that is coming within the fair play
Okay,
in the
okay,
joints.
okay.
Some fair play is permitted. What is more relevant, IVR, who have challenged themselves do not fulfill, they do not possess the requisite criteria. Even if the criteria can be relaxed, for both for Ronak and IVR, it is clear that offer of Ronak is lower, and it is on this ground that the board has accepted the offer of Ronak. We fail to see, they are in a position to judge the price difference also with this 100 difference. We fail to see how the award of tender can be stayed at the instance of party who does not fulfill whose offer is higher than the offer which has been accepted. It is also obvious that by stopping the performance of the contract, there is a major detriment. Well, this is not in our. Now, kindly come to 55 minutes.
Yes.
Ordinarily, a writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tender unless something very gross or palpable is pointed out. The court ordinarily should not interfere in matters related to tender to set at naught the entire tender process at the stage when the contract is well underway would not be in public interest. Initiating a fresh tender process at this stage may consume lot of time and loss to the public exchequer to the tune of crores of rupees. Financial burden implications on the public exchequer that the state may have to meet with the court to issue fresh tender should be one of the guiding factors that the court should keep in mind. Well, then,
yes.
The law relating to award of 56 and the state public sector was reviewed in Air India was Cochin International. It was held that the award of a contract, whether by a private party or essentially a commercial transaction, it can choose its own method to arrive at a decision. It is free to grant any relaxation for bona fide reasons if the tender permits such a relaxation. It was further held that state and agents have the public duty to be fair to all. Even when some defect is found in the decision-making process, the court must exercise discretionary power on 226 with great caution, should exercise it only in furtherance of public interest and not merely on making out of a legal point. Court should always keep the larger public interest in mind.
Yes.
But I rely upon one other judgment colored here. Kindly come to here. Well, can I give your lordship this? Well, I hand over my. This is reference 2014 8 SCC, page 804. I have taken up that particular paragraph.
Page, what is the page number?
804. Well, the copy is just coming with it.
Yes.
Kindly come to
para 114.
Yes, kindly come to para 114.
115.
Yes, 115. Similarly, reliance is also placed on Poddar Steel Corporation. Paragraph 6, as a matter of it cannot be held and bound to give effect to every term mentioned in only in meticulous detail. it is not entitled to waive even a technical irregularity of little or no significance. Thus, it was held that minor technical deviation from non-essential or ancillary subsidiary requirement can be waived, and the government would be justified in waiving technical compliance with a tender condition. The thrust of the case was is to reinforce the submission that when there is substantial compliance with the terms of the tender, government is entitled to waive any non-essential term in the tender for bona fide reasons and public interest. In any case, since project internal have to be executed through an SPV and the appellant being an SPV, the vehement inquiry that the lead member must be a company is not a violation. There were no malafides in the decision-making process. That has to be judged with, my lord, first of all, the price difference, because it's a commercial contract. If can I or can I not waive this 100 deficiency with a price difference and the stage at which they have come, where the tender is going to be awarded at the cost of what it will cost the state if this tender is not finalized today. It's a supply of, my lord, oxygen cylinders.
Lord, 3 minutes. Kindly give me 3 minutes time, Lord, just to answer your lordship's query. I have taken instruction in the meantime.
Category you applied for?
B and F.
B and F.
No, they have applied for all, A to F. A to F.
All. That's
Lord, Mr. Bhattacharya's client applied for B and F. Lord, I have taken instruction. Give me 2 minutes time to clarify this. Lord, kindly have a look at page 26 one more time.
Please, Mr. Chakravarti, please wait.
Oh,
You will get
Lord,
time.
Lord, I thought Mr. Sen is.
Other thing, my lord, kindly see, this is relation to his case of paragraph 14 of the writ petition. Now, my lord, he has also pointed out page 130 to your lordship, my lord. Now, this is not the actual document. There also, I want to say, my lord, he is trying to play, his client is trying to play a fast one. Kindly see, my lord, paragraph 10 to 12 of the writ petition, where his case regarding the other violation has been complained of. Paragraph 10.
Yes.
Your petitioner states that Annexure C, Article 2, Clause 1, similarly, every participant should have a valid license issued by Chief Controller. Attested copies of the license to be attached. Language employed is a mandatory requirement, is neither directory nor capable of subjective relaxation. Production of a valid license, answering a content in a NIT consideration. Next, 11. Respondent number 6 admittedly uploaded upon the the license on the strength whereof it sought technically. It is further stated that the bare perusal of the license unmistakably demonstrates the respondent number 6 does not possess statutory authorization contemplated under NIT in respect of medical gases. The license relied upon by pertain only to industrial oxygen and nitrogen, does not authorize the respondent to undertake activities relating to medical oxygen, nitrous oxide, medical in the manner required. And he has relied upon for this page 130. He has not shown the licenses which I have produced with my bid document, my lord, which he has not disclosed. So, my lord, this I have downloaded my bid document, which he could have. He downloaded one page, page 68 of that bunch.
Yes.
It was আমাদের bid document. এই document page 68 to 75, 80 and 82. Your lordship takes page 68.
Yes.
This is kindly see at the top, Pesos online licensing system.
But he has not argued on this.
No. What he is saying, on the strength of one document at page 130, I have not given the actual licenses, which are to be issued by Chief Controller. I am only saying whether this is a wrong document. All these licenses were given. That is
he has not argued that he has not given the license. Only with regard to the quantity, he has argued that matter.
So therefore, I take it that this point here.
I will record that. No problem.
So, as regards the other point, that is my submission. This much of fair play or this much of discretionary power they have, unless it is shown it is especially palpably malafide, accentuated by motive, the court in his discretionary power.
Thank you.
Lord, just give me 2 minutes before Mr.
Mr. Chakravarti, Mr. Chakravarti, can you, would you, Malaj?
Also, there was a writ petition challenging this award. But in that context, I will refer to the judgment passed by this court, saying that this some relaxation is permissible. And my lord, this and the writ petition, my lord, was dismissed. Kindly see, my lord. There also their case was similar to this. Kindly see. Para 3, although the terms of the NIT, para 2, your lordship will see clause 11, bidders have to have a 3 years experience. The petitioner, it is argued at the requisite 3 years experience and as such qualified on technical. Although the term did not require 3 years experience, production of all medical petitioner also had 3 years experience, production and selling. First ground of rejection is illegal. The respondents relied upon the petitioner not meeting the requirement. Then the second ground, my lord, cash reserve, all these were challenged. Ultimately, your lordship will see. Kindly come to, my lord, paragraph 15 onwards. Here also, my lord, the argument of non-essential, essential condition was brought in, paragraph 16. Argument of the petitioner, the conduct of the respondent authority rendered cash reserve condition non-essential is defeated on 2 counts. Respondents have shown from the document annexed that respondent did not meet the cash reserve criteria after shortfall notice. Having taken advantage of the shortfall notice, not challenge the same at the relevant, the petitioner cannot now argue that the said opportunity was beyond the tender terms. Then, my lord, paragraph 18, ratio of Ronak International was followed. So, my lord, this is, my lord, I also rely on this, my lord. Paragraph 26.
No. Paragraph 18 says, and the petitioner does not have the right being itself ineligible. Here, there the petitioner was itself ineligible. That's why the court has not.
There he asked for waiver.
Maybe.
There he said that the authorities should, my lord, waive certain conditions.
Okay.
My lord, these are my.
Okay.
Malaj, may I make one request? Malaj, I am not a party here. I am the successful bidder in terms of zone C and D. I have not been made a party. I was party in that first writ petition, the judgment of which Mr. Sten is showing. Malaj, your lordship is passing an order in only in terms of zone B, right? Malaj, your lordship is not setting the tender.
Zone B, that's I am not.
Yes, your lordship will clarify that in the order, Malaj. I am just here to Malaj just protect that interest.
That you can, I will deal with the zone B only.
I am so grateful, so grateful.
Lord, may I take 2 minutes time only? Lord, may I get 2 minutes audience before Mr.
Yes,
Bhattacharya
Mr. Chakravarti.
Lord, page 26, if my lord sees once, just once, page 26.
Yes.
Why so much of on this, Lord? Kindly read it with me, the middle portion, the middle box. The 100% government cylinder should be filled up by the bidder, but the bidder, so first is filling up of cylinders, government cylinders. So the contract is that I have to fill up the government cylinder supply, and in addition to that, the bidder should have sufficient stock of cylinders to replace the damaged, defective government cylinders during refilling or additional requirement, if any, in exigency. So this is in addition to the job of filling for which the tender is floated. I have to have a stock. Now, page 133, which has been shown to your lordships, this is the deck stock of the respondent number 6. This is not the entire thing. This is what they have. This is what they have in their store. Lord, kindly appreciate the scope of the job is that they will fill up the oxygens in the government hospital, the government cylinders. In addition to that, they must be having cylinders in their stock to replace in case of exigency. This respondent number 6 is an existing tenderer for zone A and zone B for the last 2.5 years. Lord, he has been successfully performing. Whenever there was a requirement, he has done that. Lord, considering this, Lord, this is a deck stock, and this may not have the requirement right now or every time. In case of exigency, they would be needing it 1 or 2. We have taken the decision, my lord, to hold them technically qualified. Not
Very nice.
consider.
Where is your decision?
Lord, page, I have shown your lordship, Lord, 30th June, the decision of the tender technical in my report, 30th June 2026. Lord, the documents that were required to be supplied, there was no shortfall in the document. We have considered that. Now, at this stage, Mr. Bhattacharya,
Mr. Chakravarti,
My lord,
you have
at this stage, Mr. Bhattacharya is inviting your lordships to evaluate the technical qualification, which is perhaps not, Lord.
no, this court is putting questions to you. Okay, this after the shortfall, you have considered all these things. Where in the resolution of the meeting dated 30th June 2026, this has been considered. Okay, he is having the 300, not having the 400, but it can be accepted. Where is that reason in the meeting?
Lord,
should
that is what I
have-
was. That is what I was showing your lordships. Yes, yes, my lord, I completely bow down. Lord, page 28 was the documents that were required to be filed. He has
28.
filed all the documents. He has filed all the documents as per page 28. Kindly seize me not once. Kindly take clause 5, page 28. These documents have been filed. So we have seen the documents. We have found that there is a subjective compliance, overall compliance, and we have technically qualified. Now, Mr. Bhattacharya's client has failed to satisfy in the financial bid also. Now, after they have failed, they have come. Now, my lord, if the tender committee is subjectively satisfied on the technical qualification of a party, not with greatest of respect, the read court may not interfere. Kindly take one judgment only, my lord. Agmatel 2022 5 SCC. My junior will hand over. 2022 5 SCC, my lord. What is the scope of judicial review before your lordship? This is not that they cannot supply. And our resolution reflects that we have considered all documents. But kindly take para 26 of Agmatel once. Look, if I could have understood that they don't have the capacity to fill, they don't have the other licenses, they have all compliances. And on the last day you come to court, you wait for the financial bid to come, you have acquiesced your right to challenge. Kindly take para 26, Lord, 2022 5 SCC, page Lord 362, para 26. Agmatel, Lord, I believe Agmatel has been given to your lordship, Lord.
Paragraph, which paragraph here? 26.
Para 26, para 26. It is Agmatel, Lord, I believe.
Which?
Ms. Simani, kindly see which judgment has been handed over. Kindly see which judgment. Lord, is this Agmatel 2022 5 SCC?
Agmatel.
Yes, para 26.
Yes.
The above mentioned statements of law make it amply clear that the author of the tender document is taken to be the best person to understand and appreciate its requirements. And if its interpretation is manifestly in consonance with the language of the tender document and subserving the purchase of the tender, the court would prefer to keep restraint. Further to that, the technical evaluation or comparison by the court is impermissible. And even if the interpretation given in the tender document by the person inviting offers is not as such acceptable to the Constitutional Court, that by itself would not be a reason for interfering with the interpretation given by the tendering authority. But we have taken into consideration all documents submitted. It is a deck stock. Mr. Bhattacharya is relying on the deck stock, which is in case of exigency may be required. On that, he wants to set aside upset the entire process. Lord, just take one more judgment, Lord. Kindly allow me to show the next report, 2022 6 SCC, NG projects. What is to be done in this sort of a situation? Although that was a contract for road construction, kindly take para 23 of NG projects. This is also an emergency contract, Milord, for supply of oxygen. Kindly take para 23.
Yes.
Maharaj kindly got that. In view of the above judgments of this court, the read court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tender. The court does not have the expertise to examine the terms and conditions of the present day economic activities of the state, and these limitations should be kept in view. Court court should be even more reluctant in interfering with the contracts involving technical issues, as there is a requirement of the necessary expertise to adjudicate upon such issues. The approach of the court should be not to find fault with the magnifying glasses in its hand. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender conditions. If the court finds that there is total arbitrariness or that the tender has been granted in a malafide manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than to injunct the exclusion execution of the contract. Their injunction to interfere in the tender leads to additional cost to the state and also against public interest. Therefore, the state and the citizens suffer twice, firstly by paying escalation cost, secondly by being deprived of the infrastructure for being present-day government are expected to work. Milord, they have come out on a point which is not very essential to the contract. It is a deck stock matter. I could have understood that the respondent number 6 has been favored. Milord, my lord knows the settled law that the Reed Court would not interfere unless there is arbitrariness, palpable malafide, and milord perversity. Milord, they are saying that instead of 400, he has 300 stock. They have the necessary licenses, they have the clearances, everything they have. And milord, today kindly appreciates he filed writ petition challenging B and F. Now he has given up F. He is considering only for B, now only for 100 cylinders. And he has waited for the financial bid to come. Lord, if he had been successful in the financial bid, he would have never filed the writ petition. This sort of a litigant, a fence sitter should not be allowed to challenge. I could have understood he has challenged before the financial bid has been published.
Okay. Yes, Mr. Bhattacharya.
These are my submissions.
I am grateful to my learned friends because they have cited judgment which supports my cause. I'll just show the relevant areas. But before that, Lord, Mr. Srijip Chakraborty, Lord, has made out a good case for me. Lord, kindly turn to page 58, which I missed to place. On the very same ground, my lord, they have disqualified other tenderers. Kindly come to page 58. This is noticed in respect of shortfall, findings during technical bid evaluation. Item 7, Shona oxygen. Apart from this, did not submit the periodical testing certificate for medical oxygen. No, test certificate for medical oxygen. No. And here, they did not file the medical oxygen certificate. I have pasted to page 130.
No, that's not the case.
Page 130.
No, that's not the case, ma'am.
Yeah, other page also does not include medical.
Page 68 to 75, your lordship will see.
Well,
I did not show that because my learned friend said.
Well, I accept Mr. Shen's 68 with regard to nitrous oxide, not medical oxygen. Anyway,
please.
And the pertinent question asked by the court isn't answered. Now that they wanted to get out of the court's jurisdiction by citing decisions.
No. What you want to say with regard to the 7 Sona oxygen?
Yes, we also find that he was disqualified because did not have that particular certificate.
This is a short document, not disqualification.
Chakravarti, you are appearing through online. Please don't disturb.
Lord, I'm sorry. I apologize, my lord.
So agitate you to protest this petition. I am staying coming tomorrow. Then
Lord,
you
I'm sorry. I'm sorry.
I will fix tomorrow.
Lord, I'm extremely sorry. I apologize. I'm extremely sorry.
Test certificate for medical oxygen, which is very important, Milord, component of supply. 4th line, Shuna was disqualified.
Approved certificate of protocol examination, testing of gas cylinder, medical examination, oxide, not submitted. Manufacturing, yes.
Now, Milord, therefore, this itself, Milord, shows that they have favored. And now kindly come to, Milord, the judgments. Milord, Mr. Shen, my esteemed friend, Milord, has relied upon Tata Motors. The Tata Motors, Milord, was a judgment delivered when the job was completed. Kindly come to, Milord, the relevant factual aspect. In that background, the Supreme Court said, paragraph 50 is the foundation for the decision of the Supreme Court. Now kindly come to last two lines. No, sorry. Before that, paragraph 48, sorry, that was a mistake. Paragraph 48 says, learned SG vehemently submitted that to ask best to issue a fresh tender notice. We are not here on fresh tender notice.
Which paragraph?
48.
Leonard SG Vehementis, yes.
Would be against public interest in the contract given to every in May so and so. Best was to pay rupees 46.81 kilometer, examined the possibility of retendering, and found that in recent past one similar tender was issued by Convergence Energy, a government of India undertaking. As for the recent contract awarded, it ended up paying 1,200 crores. More than in the present case. Therefore, at that stage, retendering would be a loss to the public exchequer. Keeping that in mind, the Honorable Supreme Court says in paragraph 50, in such cases, no question of retendering. Though there were certain mistakes, government admits that. Therefore, the ratio of 2023-19 SCC, my lord, supports my cause. My lord, we are at a stage where, my lord, the work order has not been issued.
Yes.
My lord, the technical evaluation was made on Friday and financial bid was opened on Monday. Therefore, I had no opportunity even to come to court. Therefore, Mr. Sijiv Chakraborty's submission that I was a fence there probably is a wrong perception. And the other judgment, my lord, which Mr. Sen relied upon, and Lord, the judgment of this court, which my lord has pointed out that I was not eligible, therefore the court said, you're being ineligible, you cannot argue this. And the other judgment, 2014-8 SCC, that also supports my cause. In those cases where the contract was in operation, the court, in exercise of judicial review, may ignore, because that will ultimately cause financial loss to the state. Here, that I was found L2. There's no question of the financial loss. And the contract has not yet been awarded. Therefore, at the threshold, my lord, when I have before the lordship, the Honorable Court finds, my lord, there are issues which raises doubt.
Yes.
And the tendering process, my lord, must be fair, following, my lord, that the Aram Shakti principle, which has been followed consistently. I am not going to, my lord, burden my lord with authorities. This judgment relied upon them is supporting me that in cases where such loss is apparent, the court would be slow, nothing beyond that.
And one thing, Mr. Bhattacharya, satisfy this court. Kindly come to the page 26.
Yes.
Page 26, zone of supply, district to be covered. 100% government cylinders should be filled by the bidder.
Yes.
But the bidder should have the sufficient stock. So their contention, they have now raised both private respondent as well as the authorities. Understood. So they are having the 100% capacity to supply. Only this 300 capacity has to be in stock. So
look, this is very serious. Lordship, kindly consider the COVID situation.
So that's why I'm asking, what is your answer?
My answer is, my lord, that you have to have the minimum stock available for replacement.
Okay.
If the replacement is not available, then at the emergency situation, what would be the reality? And this being the basic eligibility criteria, districts to be covered 100%, governments should be filled by the bidder. But the bidder should have sufficient stock of cylinders. But this is a, my lord, essential condition. I might have, my lord, power to kill 100 balloons, but I have the right, I have to be capable to replace it immediately by 400.
Okay.
Not having that is an essential condition.
Yes. What was Mr. Chakraborty submitting?
Page 58, what Mr. Bhattacharya has shown,
Yes.
that is not the document rejecting Sona or anybody. It is, kindly read the first line. In this regard, the bidders are requested to submit their clarification. This was the shortfall notice. We asked for these documents from Sona, not that we have rejected Sona on this ground. Why we have rejected Sona? Kindly take the technical bid evaluation, page 118. Page 118 once.
Yes.
Page 120, page 120. Sona Oxygen Private Limited was disqualified on 3 grounds. Kindly take the third ground first at page 121. The bidder not quoted the rate for carbon dioxide in BOQ, item-wise evaluation, bid submission confirmation. So they did not quote rate in the BOQ. Then cash reserve was not there. Manufacturing and supplying and transporting medical gases to hospital with 3,000 beds for last 3 consecutive years was not submitted. So Sona did not submit any document. So we have rejected his technical bid. And page 58 is a document calling for shortfall, which was done for Mr. Bhattacharya, which was done for Mr. Sen also. We have asked for shortfall from everyone. Page 50, page 115 is the document by which we have asked for shortfall from Mr. Sen's client. Not shortfall, we have given them chances. Mr. Bhattacharya's client was given 2 chances. We could have rejected him if we wanted to favor somebody. We have asked him to submit documents again and again, page 58 and page 115. Now, there is no doubt about the credibility of the process. Page 58 and 115 are the documents which Mr. Bhattacharya has annexed, where we have asked his client to submit documents which he did not.
Okay. Yes.
Just one
Now,
document.
these are my submissions.
My license for oxygen, medical oxygen, is there at page 68 of the bid document.
Yes, it's there. It's there. It's there.
Yes. The petitioner has filed the present date.
Lord, may I take a Lord's leave, Lord? May I take a Lord's leave, Lord?
Yes.
Grateful to Lord's.
He'll be there. File the present writ application challenging the rejection of the financial bid of the petitioner. And accepted the financial bid of the petitioner respondent, private respondent, in spite of the fact that the private respondent has not finally bid of the petitioner on bid as financial bid of the petitioner. It is the case of the petitioner that the financial bid of the private respondent was accepted by the respondent authorities in spite of the fact that under Zone B, the medical oxygen cylinder IP 2022, the stock must be A-type stock must be 400 numbers, but as per the document submitted by the private respondent, the A-type oxygen cylinder was only 300 numbers. Though the petitioner was having the requisite number of 400 in terms of the tender condition. Full stop. The petitioner submitted, advocate appearing for the petitioner submit that the respondent authorities have published the tender notice on 5th of March 2026 for supply of medical gases in cylinders to government hospital and health units for 2 years from the date of AOC by the for 2 years. The petitioner had drawn the attention of this court with regard to the eligibility criteria for participating in the said tender. As per clause 2, the bidder should have the capability to supply all 3 gases, gas, medical oxygen, medical nitrous oxide and carbon dioxide in the zone for which the bid is made. Clause 4 provides that the bidder should have minimum stock of 4,000 B-type and 4,000 D-type cylinders inventory with him, and all cylinders should be approved by PESO for handling the medical oxygen. Land Council for the petitioner draw the attention of this court to clause 5, table A1, wherein as per zone B, as per zone B, the A-type cylinder, the total A-side cylinder and the stock of A-type cylinder must be 400 numbers. 400 numbers. 400 full stop. He submits that full stop. The petitioner has relied upon the declaration submitted by the private respondent, wherein the A-type cylinder, wherein it is mentioned that A-type cylinder is the stock position of the A-type cylinder of the private respondent is only 300 numbers, not the 400 numbers as prescribed under zone B in clause 5, table A1. Table A1. Full. Mr. Vikas Ranjan Bhattacharya, Leonard Senior Advocate, appearing for the petitioner, submitted the respondents without considering that the petitioner was having the stock of 400 A-type cylinder, but ignoring the capacity of the petitioner, have accepted the tender of the private respondent, though the private respondent has not fulfilled the eligibility criteria, as the private respondent was not having the stock of A-type cylinder, stock of 400 A-type cylinder. A-type cylinder. Full stop. He submit that. Full stop. He submit that though the though the financial bid has also been open, but till the work order has not been issued, and prayed for directing the respondent authorities to consider the tender of the petitioner, as the petitioner is having the 400 A-type cylinder and the private respondent is not having the A-type cylinder, and to award the contract with regards to zone B as participated by the petitioner. Learned Counsel, appearing for the respondent authorities submit that the private respondent had participated in all zones, and all zones, full stop. He submit that on 5th of March 2026, the tender was floated. 27th May 2026, first notice of shortfall was given to all the participated bidders. Second notice of shortfall was issued to the bidders on 9th of June 2026. The petitioner has lodged the complaint on 8th of June 2026. And the technical bid was open on 16th of July 2026. On 16th of July 2026, the petitioner had the knowledge with regard to allowing the technical bid of the private respondent, though the private respondent was not having the capacity of 400 A-type cylinder. But the petitioner has not raised any objection or filed any writ application. The petitioner has waited till the financial bid was open, and when the financial bid is open and found that the petitioner is not selected and the private respondent was the L1, the petitioner has filed the present writ application, and as such the writ application is to be dismissed. He further submit that as per clause 5, table A1, the bidder should supply the 100% cylinder and only to have the stock in emergency situation. And thus the authorities have considered that though the petitioner and the private respondent has qualified with regard to the all eligibility criteria, only with regard to the shortage of 100 shortage of 100 cylinder has been relaxed and awarded and technical bid was allowed. And after opening of the financial bid, it was found that the private respondent is the L1 and the petitioner is the L2. L2. He further submits that, full stop. The Land Council for the state has relied upon the judgment in the case of Agmetal India Private Limited versus Resources Telecom and others, reported in 2022, Volume 5, SCC 362, and submits that the Honorable Supreme Court has categorically held that the technical evaluation or comparison by the court is impermissible under the writ jurisdiction. He further relied upon the judgment in the case of NG Projects Limited versus Vinod Kumar Jain and others, reported in 2022, Volume 6, SCC 127, and submit that the court does not have the expertise to examine the terms and conditions of the present day of economic activities of the state, and the limitations should be kept in view. The court should be even more reluctant to interfere with the context involving technical issues, as there is a requirement of necessary expertise to adjudicate upon such issues. Full stop. And Counsel Mr. Sakya Sen, London Senior Advocate, appearing for the private respondent, submits that the private respondent has submitted all required documents as prescribed under the technical bit. Under the technical bit. Full stop. After considering the documents submitted by the petitioner, private respondent, the respondent authorities have accepted the technical bit of the petitioner. The petitioner had the knowledge before the technical bit was accepted that the private respondent has submitted the certificate having only 300 capacity of A-type cylinder. But the petitioner has not raised any objection and has waited till the opening of the financial bid. When the financial bid was open, when the petitioner came to know that he was the L2 and the private respondent was the L1, has filed the present application. He further submits that as per clause 5 table A, the authorities have found that the private respondent is having the capacity of 100% supply of the cylinder and stock of 300 A-type cylinder. Thus, the authority have relaxed with regard to the 100 numbers of the cylinder and accepted the financial technical bid as well. Technical bid. He further submit that with regard to the license, other documents, the petitioner has submitted all the documents and the respondent authorities are satisfied with the documents submitted by the petitioner, private respondent. Mr. Sen relied upon the judgment in the case of Tata Motors Limited versus Brihan Mumbai Electric Supply and Transport Undertaking within bracket BEST and others, reported in 2023, volume 19, SCC, page 1, and submits that the court must realize the court is normally loath to interfere in the contractual matter unless a clear-cut case of arbitrariness or malafidis or bias or irrationality is made out. The petitioner has further, the private respondent has further relied upon the judgment in the case of Jal Mahal Resorts Private Limited versus KP Sharma and others, reported in 2014 8 SCC 804, and submits that minor technical irregularity and deviation from non-essential or ancillary / subsidiary requirement can be waived, and the government would be justified in waiving technical compliance with the tender conditions. He further relied upon the judgment passed by the coordinate bench of this court in WPA number 7987 of 2024. In the case of Siboram Bhatta versus State of West Bengal and others, and submits that in the similar situation, the coordinate bench of this court has dismissed the writ application. Full stop. Heard the learned counsel for the respective parties peruse the materials on record and the judgments relied by the parties. Full. Clause 5, Table A, Zone B provides that the bidder should possess B-type cylinder of 1500 numbers, A-type cylinder of 400 numbers, and D-type cylinder of 1000 numbers. The private respondent has submitted the declaration wherein it is mentioned that, wherein it is certified that the A-type cylinder is 300 numbers. Full stop. This said fact is also admitted by the respondent authority that the private respondent is not having the capacity of the is not having the stock of 400 A-type cylinder. As provided in the Zone B of Class 5, Table A. The specific the contention raised by the respondent authorities is that on 30th of June 2026, a meeting of Tender Evaluation Committee was held. In the said Tender Evaluation Committee, the Tender Evaluation Committee have considered the documents submitted by all the 7 bidders. And after considering the documents, it was found that the petitioner and the private respondent are fulfill the criteria for the technical bid. Accordingly, the technical bid was open. He submitted that the authorities have found that he submitted in full stop. As per the contention of the respondent authorities, that the private respondent is able to supply the 100% cylinders to the government and is having the 300 A-type cylinder. He possesses the A-type. He possesses 300 A-type cylinder. Thus, the full stop. The stock is necessary for the emergency situation. And as such, the respondent authorities have find that have relaxed the condition of the private respondent with regard to the 100 numbers of the A-type cylinder and allow to participate in the technical bid. Technical bid. This court finds that once the authorities have decided that the bidder should possess the specific quantity of the A-type cylinder, and that has been published in the tender notice. In the tender notice, there is no condition in the tender notice that the authority will consider with regard to if the bidder is having the less quantity of the stock. The resolution submitted by the state authority dated 30th June 2026 also does not record under which situation the authorities have relaxed the condition by condition, knowing that the private respondent is not having the 400 A-type cylinder. They have only taken the decision with regard to the documents submitted by the parties. There is no decision with regard to relaxation of the condition by allowing the relaxation of the petitioner. Instead of 300, instead of 400 stock, the 300 can and the bidder who is having the 400 300 capacity stock of A-type cylinder can also be participated. Full stop. The judgment relied by the in the case of Agmetal India Private Limited Supra, the Honorable Supreme Court held that the author of the tender document is taken to be the best person to understand and appreciate the requirements. In the present case, the authorities, after taking into consideration, have decided that the stock must be minimum 400. And the tender document was published. But at the time of accepting the tender of the private respondent, knowing the knowledge that the private respondent is not having the 400 numbers of the A-type cylinder, have accepted the technical bid without assigning any reason. In the case of NG Projects Private Limited, NG Projects Limited, Supra, the Honorable Supreme Court has held that the writ court should refrain itself from imposing its decision over the decision of the employee as to whether or not to accept the bid of a tender. In this case, the specific case made out by the petitioner that the respondent authorities, by violating the terms of the violating the eligibility criteria of the terms of the bid document, have accepted the technical bid of the petitioner with regard private respondent with regard to Zone B. As the private respondent was not having the stock of A-type cylinder of 400 numbers. Full stop. In the case of Tata Motors Limited Supra, the Honorable Supreme Court held that the court normally loath to interfere in the contractual matter unless a clear case of arbitrariness or malafidis or bias or irrational is made out. In the present case, this court found that in the tender condition, a specific condition has been laid down that the bidder should possess a 400 numbers of the A-type cylinder. But admittedly, the private respondent was not having the 400 numbers of A-type cylinder, and they have not taken any resolution. And in the resolution dated 30th June 2026, the authorities have not taken any resolution that that condition was relaxed. But the respondent authorities have accepted the tender of the private respondent with regard to Zone B. In the case of Jal Mahal Resorts Private Limited, within bracket Supra, the Honorable Supreme Court held that as a matter of general proposition, it cannot be held that an authority inviting tender is bound to give effect to every terms mentioned in the notice in meticulous details, it is not entitled to waive even a technical irregularities of a little or significance. But in the case, it is not, this court did not find any, did not find that the irregularity accepted by the private, by the authorities is no significance. The tender is with regard to supply of oxygen cylinder. It is the specific condition of the authorities that the bidders should possess a requisite number of A-type cylinder, so that in emergency situation, the cylinder should not be supplied by the contractor. But in the present case, the quantity was fixed of 400 numbers. But the private respondent was not having the quantity of the 400 numbers. In spite of the same, the authorities have accepted the same. Full stop. In the case of Siboram Bhatta, Supra, this court find that this said judgment is not applicable in the present case, as in the said case the petitioner was ineligible to participate in the tender. But in the present case, the petitioner was eligible, his technical bid was accepted, he was having the total capacity with regard to the numbers of the cylinders, but ignoring the capacity of the petitioner with regard to the stocks, the respondent authorities have accepted the tender of the private respondent, though the private respondent is not having the capacity of 400 A-type cylinder. Considering the above, this court find that by accepting the respondent authorities, by accepting the tender, the technical bid with respect of Zone B have committed an error. This court find that the respondent authority arbitrary and whimsical by ignoring the capacity of the petitioner, that the petitioner was having the capacity of stock of more than 400 A-type cylinder, and the private respondent is not having the A-type 400 cylinder, have accepted the same. Accordingly, with regard to the tender of Zone B, allowing the accepting the financial bid of the private respondent is set aside. Full stop. The respondent authorities, full stop. It is informed by the parties that till date the work order has not been issued. Accordingly, respondent authorities have directed to consider the case of the petitioner with regard to the Zone B and to pass appropriate order. WP is disposed.
Just one clarification, although your lordships has said Zone B, kindly clarify this will not be applicable to Zone C and Zone D.
This court has not gone into the other zone.
I'm so grateful, deeply obliged.
Affidavit service be kept.
9 and 10.
This is my application.
Yes.
We filed a report, my lord. Assist your lordship to the best extent possible.
My lord, it relates, my lord, to certain deductions which has been made by the respondent alleging that there has been a loss which has been incurred by them in view of a cost benefit analysis which has been done, not disclosed to me, and in with regard to merchant discount rate charges. Now, in short, my lord, a merchant discount rate generally happens, my lord, when a credit card is given to someone, my customer, let's say, he swipes it. Then the amount of transaction that goes, my lord, to the account of the bank at the first instant. The bank discounts the commission, their commission, and reimburses the balance amount to me. Now, what has been alleged is that they have incurred losses in view of MDR charges. Well, that is something which is appearing to be a bit strange to me, because the discounting and the commission is already taken by the bank at the first instance. So there cannot be any loss which can incur to them before they reimburse the amount to me. Secondly, they say that I have not kept a certain amount of 30 crores amount in my account as a security sort of a thing to show minimum balance, and that is in violation. That is nowhere in the agreement. No notices ever has been given. Number three, my transactions exceed more than 10 crores, more than 100 crores. Well, that is also nowhere in the agreement itself. Now, my lord, in short, your lordship would kindly come to, well, this in short is the fact behind the.
What is the prayer?
My lord, prayer, my lord, are a bit, I would say, I would, my lord, in fact, my lord, only pray. My lord, the prayer says.
Directly correspond to provide the petition with the breakup. How the
Well, I tell you, yes.
Then the report is
Well,
required.
that is one. That is one. But at the interlocutory stage, my lord, what has happened is they have deducted 1 crore another amount, and the balance which was there, that they have taken, they have put the whole account on lien. Well, that cannot happen. When a lien, that amounts are not disclosed, nowhere it is given. Now, if a lien is created on an account, then what happens? A lien is created on a specified quantity, and the balance of the amount which is there in the account that is allowed to function. That they have also stopped. But my interlocutory prayer is, let them file report, let them file affidavit, what they want. But my lien on my account needs to be lifted and account needs to be made operational. That is what I am praying. Because everything has come to a standstill because of that. No card swiping can take place in the first two matters. That is my interim prayer. And the report, whatever they want to give, that is my prayer B. At the instant, at the very first instant, let them lift the lien on let them keep the lien which they have made, but let the account be made lien free for the time being.
With regard to the other, you may allow to operate keeping the account.
Correct. That is my interim prayer. Now, my lord, in my third writ petition, there's a third writ. 3. My lord, in item number 11. My lord, they have made another further thing. They agreed that yes, there was certain amounts. Then we said we are closing the account. We informed them. They kept the terminal open. And what happened was, even after the account was closed, they kept the terminal open.
Why so friendship with you?
I know. I don't know. Now, my lord, in fact, my lord, since if they have the transactions where I've agreed that what was agreed, they say was 0.9% commission. I said, well, I am agreeing to a 1% commission to you because my transactions are high. Let's go by it. Then, my lord, in that they agree, yes, the 1 crore amount, there was a wrong swiping of card amounting to 1 crore. Because the terminal was opened after the account was closed. Now what they say is, yes, I am reimbursing this amount after you open another new account with our bank because it's difficult to transfer it to the existing closed account. I say that yes, I open the account. They say they transfer it, they transfer. And thereafter they withdraw it again. That 1 crore.
Yes.
This is not easy as it seems. It took me almost an hour to understand what is the concept of MGR charges and what are the concepts of levying this. In my humble way, may I take 2 minutes? But what are MGR charges? Merchant discount rates. Why are they given? But a merchant comes to us, says that I will use a POS machine or a QR code or a gateway to avail through your bank. And for that, suppose Visa, RuPay or MasterCard, they levy charges on the merchant for each transaction. Suppose for a transaction, Visa charges 4% of the transaction value. But if a purchaser like me comes to a store and swipes a card, if I have to pay 4% extra, but I may not buy that product because it is
Extra rate.
It is extra. So what the merchant says that you give discount, bank, you give discount to me on that 4% charge, so that I can share that 4% with you and me, so that Visa gets 4%, but I do not levy the purchaser of that 4%. This is usually happens back end when I swipe a card. So they comes to me, I give a discount of 2%, and they give
2%.
from their end 2%.
So means you reduce the 2%.
Yes. And now comes this cost and profit analysis, which my learned friend has said that we did not share. What is this analysis about? This analysis is that suppose he transacts, he says that I transact during a year for 5 crores. We now analyze that 5 crore transaction would amount the bank of say 10 crore rupees, say 1 crore rupees, and to them another 1 crore because it is 50-50. But for giving, we are a business. Ultimately, bank is doing business. We have to have profit even after giving discount. So we analyze that even if we give a benefit of 1 crore, we have to have that 1 crore satisfied by having some balance in his account, so that we can get the benefit by crediting the money to RBI from which we gain, because we have the corpus which RBI uses. So ultimately, he has to maintain a fixed sum of money to have the benefit given to us. That is agreed at, suppose what my learned friend says, 10 crores per year. That is agreed. For 10 crores, we can give him that 50%, that 2% rate of discount. But now what happens is, he uses the card and gets a transaction in 1 month of 100 crores. In 1 month, he transacts with 100 crores.
What is the business you are having?
Yes.
Well, it's a travel agency business. No, but all these things have to be shared to me.
There is interesting fact. The moment 100 crores are swiped, the 4% of that 100 crores multiples to 7,000, several crores in all. So we have to pay, but we cannot give that 50% benefit of that several crores because we had agreed considering the analysis of 5 crores only. Now, to avail or to have a benefit of that 50%, he has to maintain in respect of that 100 crores.
How much? How many days it took the 100?
1 month. In 1 month, he transacted 100 crores. He had agreed of 10 crores in 1 year.
But I have given my accounts.
Going into the actual details, but these are the gross errors which he had come. I will not go into the errors, but I am now entitled to have the amount or the MDR charges levied which have crossed the threshold.
10 crore.
Yes. So I have
Now 90 crore you are charging
not
4%.
90 crore, it may be
Whatever.
whatever.
You're charging 4%.
Yes, we have to, because ultimately we had to pay to Visa, RuPay, MasterCard, whoever, because we had to. Once the transaction happens, we have to pay.
How the merchant will get
Lordship,
benefit
I'll just come to
of
that.
the business if you take the if you are telling that online on all these things, and if you're asking you
He has to give us the projected turnover per year. If he gives us the projected turnover of 10 crores and transacts 100 crores, we cannot help.
that is correct.
My lord, now, my lord, lot of things have been said. Now, my lord,
be on affidavit.
everything has to be there in the agreement.
Let they come.
The agreement is here, I've annexed.
Let they come the
My
bigger
lord, one thing, my lord, I am on an interim.
Now what is the total? What is the dues against the petitioner?
Use more than 1 crore. We have only marked lien of 1 crore since 1 crore was available.
Well, let them move the account.
Let the account may be operate.
Demand notice to him also.
Let the lien account
Account
be
be
free.
let the account be open. Let the
Operational.
account be operate with regard to the keeping the amount lean and in lean. Why your
Well, no demand notice has yet been given. Nothing given. Well, your lordship would kindly see the 2 or 3 documents which they have issued. Nothing.
Demand. If you're not given the demand, and
Say, as and when it will come.
1 crore 41 lakhs. Okay, you keep that amount in
He doesn't have 1 crore 51 lakh.
1 crore, whatever it may be. Whatever the amount as on date, let it be kept in line.
Can direct me to disclose exactly what is the amount we want to charge on him by 5-7 days.
That they have not done. So it's an admitted position now.
Saying that not done. If we have not done. So let my lord directs me to inform them. Let them deposit the amount, subject to depositing that amount and marking it as lien, subject to your lordship's consideration.
Well, as and when the account is functional, well, they cannot freeze my account without giving a notice.
Correct.
This amounts to freezing.
We have to recover.
It's not a criminal offense.
You have to recover, but how you can
My account being functional, I cannot do business.
Without the demand.
I cannot
Demand you give,
nothing given.
Then you have some other procedure for recovering.
Yes, there is.
Then
There is. That's mentioned in the agreement. They have not issued anything.
I have
Counsel for the bank press for time to file report. Full stop. Let the report be filed by 24. By 29th. By 29th, after serving the copy to the land council for detailed report with regard to the account of the petitioner by 29th of July 2026. After serving the copy to the land council for the petitioner's liberty to take exception to the report by 5th of August 2026. Release the matter on 6th August under same heading.
But in the meantime,
Come on, then I will see. Let the report come.
Unless and until
I appreciate.
They have treated a lien.
Correct. What is actual they have treated. Let the come on affidavit. Let the come on affidavit. How
What they are going to do is now, they are going to create certain amounts.
That's why if they will file the affidavit disclosing all the accounts, let the court examine whether they can do or not. If they cannot do, then the court will.
My accounts are there before your lordship.
Correct, but let the first.
But without the account being operational, they won't be able to recover also.
11.
Without making it
Let
operational.
1 week is required. Come on 1 week. Let the report come because this is amount. We have to court has to consider all these things. The court cannot so directly pass an order.
Without notice, without anything.
I appreciate. Let the report come. How they have kept the account lean. Let something come on record.
But I'm saying let them keep it in lien.
Yes. Come on. Come on.
31st. My lord fixes 6th, there is no problem. But instead of 29th, 31st.
Come on 30 by 5th, release the matter on 6th. Huh? Yes.
Well, all the 3.
Yes. 9, 10. 9, 10, 11 same. Huh? Yes. Yes, 12.
Wait, please, Your Lordship. Today I am
it's fallen on me, my lord, to make the submissions. My lord, very briefly, I'll not argue anything, my lord. My lord, I have only one submission for your lordship's kind consideration. My lord, if I'm shut down, I'm shut down. My lord, I understand the difficulty, my lord. I really don't have a way to improve the facts. My lord, may I only pray for this indulgence, subject to consideration. If this writ petition, my lord, if this be treated as a representation in the Calcutta office, only this, my lord. This representation be treated with the writ petition.
But I am giving liberty to withdraw and file a detailed representation to the Calcutta office if any representation may considered within a period of 1 week, whatever it may be.
My lord, today, my lord, if either, my lord, I'll be praying that if the writ petition is considered by itself, otherwise, I understand.
That is
Otherwise, no, indeed. Then, my lord, may I only pray that kindly, my lord, grant us the liberty to approach the Bombay High Court and pray for relief, and kindly, my lord, record that every point is kept open.
Correct.
My lord. Only
I am only withdrawing. You are withdrawing. You are withdrawing.
We don't have instructions to withdraw. My lord, may I only pray, or if, my lord, if your lordship permits us to withdraw with a recording, my lord, that all the points are open, and since the jurisdiction is Bombay, so that they can't take another point only this much, my lord.
Okay, then I am passing an order on the jurisdiction. I am the court is not entertaining the matter. It is liberty to the petitioner to move before the appropriate court, and this court has not gone into the merit of the matter.
Lordship, may I only pray for one indulgence? If one line may be added, if the petitioner seeks to have a representation in the Calcutta office, they are at liberty. Only this much. Very well, very well. May I leave it to your lordship? I leave it to your lordship. I will not make any further submissions. I won't, my lord.
At the Land Council for the respective parties, the Land Council for the respondent has raised the point of jurisdiction and submits that no cause of action arose within the jurisdiction of this court, as the office of all the authorities and correspondence of the petitioner with the authorities are made outside the jurisdiction of this court. Consider the submission made by the counsel for the respondents, peruse the materials on record. This court find that this court is not having the jurisdiction to entertain the present date application. Accordingly, the writ petition is dismissed only on the ground of jurisdiction point. Full stop.
Dismissed as withdrawn, my lord. We'll withdraw it. Dismissed as withdrawn. Otherwise, we'll be suffering an order.
And Land Council for the ऊपर बोला ना, had the Land Council for the respective parties peruse the materials. क्या बोला ऊपर? Made by the petitioner is outside the jurisdiction of this court. Full stop. Land Council for the petition prays for withdrawal of the present date application with the liberty to approach before the appropriate court having jurisdiction. In view of this submission made by the counsel for the petition, WPA number 17461 of 2026 is dismissed as withdrawn. It is made clear that this court has not gone into merit of the matter.
I'm very deeply obliged, very deeply. I apologize not for wasting the lordship's time with us. Very deeply obliged.
Yes, next.
I appear for the writ petitioners, my lord, in this matter.
Yes.
My lord, kindly permit me to appear on the virtual mode. My
Yes.
lord, limited experience, my lord, I have not seen 4 forensic audit reports in one case. Your lordships deal with these matters every day. I want to show your lordship, my lord, how the banks, all these consortium of banks, are misusing the process of law. Kindly have, my lords, only volume 2 and volume 3 for the time being.
Mr. Thakkar appearing for. The petitioner company who has filed the writ petition is in resolution. Is in the CIDP.
Mr. Bose, please. Yes, you are the fraudulent auditor. Mr. Bose, please hold your horses. My lord is very patient.
But the question is what locus?
Yes, what locus? I am petitioner number 2 director. Mr. Bose, please don't interfere. As it is, I am on the virtual mode. Please.
So, well, kindly appreciate the writ petition can only be carried forward by the resolution professional on behalf of the company, which is in CIRP. So that's why your lordship on the last occasion directed whether the resolution professional wishes to carry forward or not. The entire cause of action is directed against the petitioner company.
As the RPS filed an application on the last occasion, he has taken
I have filed an application, my lord, to transpose the company from petitioner number 1 to respondent. Petitioner number 2 is the director. The director is being declared a fraud. So I don't understand what this question of locus is, because he doesn't want your lordship to see the merits. Kindly have volume 2, please, my lord, page 231. 231, volume 2. Mr. Bose, what is your locus to object? I don't understand. You're the forensic auditor. You're the forensic auditor, Mr. Bose. What is your locus to object?
Indicate that we don't have a. This is not.
Yes. I don't understand what is Mr. Bose's problem.
Can
Can
you
you see
see
page 231? Page 231, my lord, is the first forensic audit report. Volume 2, your lordship has.
Yes.
Page 231. Kindly please make a note of these page numbers, please, my lord. Page 231 is the first forensic audit report dated 19th March 2024.
Page 231 of which? Writ petition?
Writ petition.
Yes, please, my lord. Writ petition, volume 2. Only I'll kindly make a note of these page numbers first, my lord, and I'll show your lordship, my lord, the level of fraud and why Mr. Bose is so agitated.
No.
Well, at 11.
Mr. Thakker, first the record is to be regularized. You file an
Yes,
application for first you have to transpose from the petition number 1 as the petition
Very
number 1 to be transferred from as a
I'll
respondent.
tell you, lordship, what the applications are. There are 3 applications today.
Yes.
Can 1 is intervention of other suspended directors.
Yes.
They want to be added petitioners.
Okay.
Because when the writ was filed, company was espousing their cause, protecting their interest along with 1 director. Now the other directors want to be added party. That is can 1.
Okay.
Can 3, my lord, is transposition of the company from the array of parties from petitioner to respondent and implement of the resolution professional in his place and stead. That is can 3. Can 2 is, my lord, become redundant now by reason of can 3.
What is the can 2?
Can 2, my lord, was for amendment of the petition to bring on record the fact that the company, that is petitioner number 1, had been admitted in CIRP. And to implead the RP in place and stead. But can 3, my lord, is more comprehensive. Can 3 records both. Can 2 I can withdraw, and can 3, your lordship will allow can 3 by transposing company to the post respondent. Because there's no relief sought against the resolution professional. But just because the company was there, now it's being transposed as a pro forma respondent. The reliefs are claimed against the bank and the auditor whose cause Mr. Bose is so vehemently espousing. After he has given his report, I don't understand why is he so agitated.
The challenge in the writ is in respect to the forensic auditor's report.
You are the respondent number?
13.
Auditor?
No, respondent number.
Mitra.
Yes, yes.
And company?
Yes, yes.
You are for the auditor?
Yes, but.
Yeah, what is your objection with regard to 1 and 3?
Yes, kindly take 3 first. But kindly take, I have to show your lordship the writ petition. Say, but today in can 3, they are seeking transposition of the petitioner number 1 as a respondent. Now, if your lordship transposes petitioner number 1 as a respondent, my lord, can the writ petition survive? So now, my lord, kindly take the writ petition once. And my lord, kindly come to paragraph 2 of the writ petition.
Yes.
Your lordship will find paragraph 2, the petitioner number, kindly take the cause title once, before I take your lordship to para 2. Your lordship will find para 1 is the company and para 2 is the director of the company. And kindly see the pleadings at paragraph 2. Petitioner number 2, being the authorized signatory of the petitioner company and is duly authorized to file the instant writ petition, kindly make a note of this. On behalf
गाड़ी घुमा लो फिर
kindly mute him. Okay, bolun mute kore debe.
Yes.
On behalf of the petitioner number.
Hey, mute karo. Yes.
My lord, on behalf of the petitioner number 1 company, is your lordship found that, my lord? the writ petition has been signed, verified and instituted by the petitioner number
Yes.
to the petitioner number 2. So this is why the petitioner number 2 is carried as a party in the writ petition. Nothing more, nothing less. Now, my lord, dear lordship will kindly see. So what is the cause of action in the writ petition, and the challenge in the writ petition is by whom and for what? Well, today the director's cause of action, if any, is not a part of this writ petition. So, well, if there is any cause of action or any right of the directors of the company stands affected, there presently the suspended board of directors. Well, if there is, there has to be a separate writ petition if there is any. Now, well, kindly have a look at some of the paragraphs of the writ petition. Now, well, kindly take paragraph. There is a paragraph 6 where they have made out, for better appreciation of the Honorable Court, the facts of the matter as stated below. Your Lordship will find the sub-paragraph relates entirely to the respondent number 1 company, well, who was the borrower of a consortium lending, and there was a default. Thereafter, there was the account was classified as a fraud account. It was red flag, a forensic audit. Thereafter, there was a subsequent audit. So the forensic audit made red flagging of the account in terms of the fraud circular is under question. Now, my lord, if your lordship will, after the sub-paragraphs end, if your lordship kindly comes to the next paragraph, at paragraph Z, if your lordship kindly takes paragraph Z at page 17. October 2023, respondent number 1, in utter disregard to the fact that the petitioner had all times maintained financial discipline. Who was financial discipline in the company? The principal corporately proceeded to classify the account of the petitioner as a non-performing asset in violation of the Master Circular on Prudential Norm for Asset Classification. Then, my lord, kindly take paragraph AA. On 16th November 2023, respondent number 1 issued a demand notice under section 13(2) of the Securitization Act. Now, my lord, your lordship can make a note that the demand under the section 13(2) is 1100 crores. It is only a figure of 1100 crores. Then, my lord, kindly take a note of, my lord, paragraph BB at page 18. Further, on 20th December 2023, a letter bearing reference number such and such, the respondent number 1 issued an appointment letter to the respondent number 13. Conducting, can you make a note of this? Petitioner company for the review of the period from blank to blank. Then, my lord, kindly take once paragraph CC and then paragraph DD. Kindly take paragraph DD. On 27th of December 2023, the respondent number 1 informed the petitioner that its account has been reported as red flagged account by all lender banks in the consortium. The respondent number 1 appointed respondent number 13 as a forensic auditor for conducting the audit of the books of the petitioner. Whose books? The petitioner company's books. Now, my lord, kindly come to the cause of action part. My lord, kindly take paragraph KK at page 22. It is pertinent to mention here that apart from the forensic auditor, the respondent number 1 led consortium had also appointed such and such to conduct audit analysis with regard to bank guarantees and letter of credits. Then, my lord, kindly take paragraph MM on the same page towards the bottom of that page. Arbitrarily, these are there about what? About the forensic audit. They are not happy with the forensic audit report. Then, my lord, they say multiple allegations as to why the forensic audit report was questioned by them. Now, my lord, now kindly come to the grounds. My lord, kindly come to paragraph 7 at page 33. a show cause that was received by again the petitioner company. Then my lord, kindly take para 8. Well, this is the show cause to declare the petitioner company as a fraud. Para 8. Then my lord, para 9, willful defaulters notice. Then my lord, kindly come to paragraph 13 under grounds. The above narration of facts, para 13, at page 17, that the above narration of facts reveal that the petitioner received 4 forensic audit reports from 3 different banks, wherein the reports as provided by the pro forma respondent number 3 and 4 are the same, but the report provided by respondent number 1 is different, which clearly establishes the collusion, connivance between R1 and 2. The forensic audit report submitted by respondent number 13 is malafide, baseless, prepared in collusion with detriment of the petitioner, and cannot be relied upon for the following grounds. Now, my lord, kindly come to the prayers. So, your lordship will see each ground concerns the company. If any right of anybody is affected, this is the company, nothing, nobody else. Then, my lord, if at all. Now, my lord, kindly come to the prayers. At page 52, at the end of 52.
Yes.
Your lordship can take 53.
Recall deciding the cancellation of forensic audit. Yes.
And then
Setting aside the forensic
certiorari quashing the forensic audit. So, whose cause of action is it? The company. The company is in CIRP.
Yes.
The carriage of proceeding is with the company. Now, if your lordship, section the CAN 3 is, as Mr. Thakkar says, CAN 3 is now become the primary application because they want transposition of the petitioner as a respondent. Now, if it is transposed as a respondent, who will carry forward this? This cause of action? The cause of action is entirely of the company. The respondent number has the right to represent the company. Being a suspended board of director under the Insolvency and Bankruptcy Code, the board has become a functus officio. It has no further legal right to represent the company's interest. It can at best protect his interest, individual interest.
Yes.
As a board, it has no right.
Yes.
So, this application, in my respectful submission, is thoroughly misconceived. And the writ petition has lost its force, and this is become by passage of time and by operation of law, it's become infructuous.
Which one?
The writ petition. The company is in CIRP.
Yes.
The resolution professional at best, which wishes to carry forward the proceeding, that's different.
Yes, Mr. Thakkar.
But before Mr. Thakkar commences, I am for the respondent number 6, HDFC Bank. There is no cause of action pleaded against me. I have been impleaded just as a member of the consortium.
That's why you have been engaged.
That is good for me. Yes, I was just about to say that. But this is some sort of an instruction which I received that I have to say this to the court.
My lords, kindly have.
They will
I'm
consider
grateful.
expunging my name from the writ.
Let me say. Yes.
I'm grateful to Mr. Bose for taking your lordship to the petition. He did not show your lordship the prayers. Kindly see prayers C once, please, my lord.
Prayers of the
Prayers of the writ petition. He took your lordship to the petition but omitted the prayers. Kindly see prayers C.
To the prayers.
A writ in the lordship has a writ in the nature of prohibition do issue prohibiting the respondents and each of them together with so and so, qua the petitioner and its directors. Your lordship has seen more than every day. Your lordship sees hundreds of matters of fraud reporting and willful defaulter reporting. It affects both the petitioner and its directors. So their prayer is for protecting the petitioner company as well as its directors. Then kindly see prayer E. That is the interim prayer. But the main prayer is prayer C. Then your lordship kindly sees the verification also. since so much has been said about a writ petition, kindly see the verification also, please, my lord, for the sake of completeness. Page 55, paragraph 1. I am the authorized signatory of the writ petitioner number 1 company herein above, and I am the writ petitioner number 2. I am well acquainted with the facts so and so. I have been duly authorized and I am competent to make and affirm this affidavit for and on behalf of the writ petitioner number 1 above name, and for myself, that is the writ petitioner number 2 above name. I think then, if your lordship permits, I can address your lordship on merits. Writ petition is for protecting cause of both petitioner number 1 as well as all its directors. One director, incidentally, is petitioner number 2.
Yes.
So it's not that the writ has become infructuous. Now, if I may trouble your lordship with the merits once, please, my lord.
Yes.
Because Mr. Bose, being the forensic auditor, supposed to be an independent person at the end of the day, his apprehensions are very justified. Kindly have volume 2 once, please, my lord.
So, my lord, this is subject to the application. So, my lord,
kindly have volume 2 once, please.
Merits. My lord, on merits, it cannot be addressed today. My lord, can 3.
No, with regard to can 1, what is the can 1?
Can 1 is for addition of the other directors, my co-directors, or
Yes.
rather the erstwhile board of directors who filed an application to be included as party petitioners. So all petitioners will have only one lawyer, my lord. Petitioners cannot address your lordship through different lawyers.
Give it to this. Another misconceived application. No, I'll tell you, lordship. My lord, today, my lord, based on the pleadings, the directors have to be implemented. My lord, under the scheme of the code, the insolvency and bankruptcy code, my lord, as a director of the company, you cannot be implemented. You may your rights may have been individually affected. But if your rights are affected as a director of the company, once the company goes into resolution,
They can't be director.
They cannot represent as a member of the board of directors.
I am not representing Mr. Bose. I am representing in my individual capacity as erstwhile directors.
File an individually, you have to file a writ petition.
Yeah, prayer that they may be individually. It is not there being the director.
Not in this writ petition. It cannot be in this writ petition. Well, if your lordship looks at the structure of the writ petition, your lordship will decide a writ petition based on the pleadings made, based on the cause of action and the relief claimed. Well, Mr. Thakkar referred to the paragraph C of the writ petition. C is dependent on paragraph A, prayer A and B,
Correct.
which is the mandamus and the certiorari seeking the setting aside and cancellation of the forensic audit report.
Correct.
So the prohibition, the relief, the prayer for prohibition is dependent on prayer A and B. And the entire cause of action I have taken your lordship to the writ petition is that of the company. The forensic audit was made of the books and accounts of the company.
Correct.
And the directors were managing the affairs of the company.
Correct.
So because they were managing
On
the
the basis of
affairs.
the forensic audit, the bank is taking the action to the company as well as the directors.
No, my lord, against the directors.
Against the
So,
directors.
if the rights of the directors, rightly so, if the rights of the directors are otherwise affected,
Correct.
then the directors have to individually and separately come up and say that whether I was involved or XYZ, whatever their rights may be affected, they may come up with separate reasons. All directors may not have the same reason. So that is a different issue altogether.
That is up to them to, that is the merit of the matter. But at this stage, if they wanted, that should be pleaded in the writ petition, then they are taking their own risk.
No,
That is the matter of the merit of the matter. At the time of merit of the matter, you can raise objection where is their pleading on that. At this stage, they only wanted to, they may be added.
Yes.
Correct. If they may be at the court is not going to pass the order judgment on merit in or anything, only added. If they have been added and they are conscious that this affidavit is affirmed by one of the only person and other persons are not been.
Yes.
And you can take all the thing and they are taking the risk of that.
Yes.
So at this stage, how the court can say no, it cannot be, they cannot be.
I'll tell you, Lordship, if your Lordship considers the principle of addition of party.
Addition of party.
Now, the addition of party is based on the cause of action in the main proceeding.
Correct.
Now, my lord, he will be imputed. My lord, he is an effective party, whether it is proper or not, and his presence is necessary for effective adjudication of the issues in the writ petition. Only then, what I am trying to contend is the issues in the writ petition is confined only to the company and the books and accounts of the company.
But simultaneously, you have not audited with regard to the director's duties and all. You have given a simple one forensic report. One forensic report is to be considered by the bank for declaring the fraud or willful default or whatever it may be. So the cause of action arose from the forensic audit report.
Yes.
So once the company has challenged the forensic audit report and they are also telling that yes, forensic report is so, where is the bar for adding them as a party?
No, I am saying there is, the bar is in the nature that the subject matter is of the company. Now the directors are independent individuals who are managing the affairs of the company at that relevant point of time.
Correct, no problem.
So not that they are separate. So they were just managing the affairs of the company. So if they say that because I was managing the affairs of the company, I may also be declared as a fraud because of the company declared fraud, I was a managing director.
Correct.
Then it is your individual right that you are espousing. Because today, under the code, once the company has been declared as an insolvent company or has been admitted into resolution, the board becomes functus officio.
Correct.
The board is replaced by the resolution professional.
Correct.
So what I am trying to say that their rights may be affected. So if their rights are affected, it cannot be in the subject matter of this proceeding. They have a right, they can file a separate writ petition. I am saying this writ petition is confined to the rights that was affected by the forensic audit report with respect to the company books and accounts. Directors' books of accounts or directors' involvement was not questioned here. Based on the books and accounts.
Now, books of account with regard to what? Company?
Company.
And books of account maintained by whom?
By the company, in accordance with the provisions of the Companies Act.
Company cannot maintain
No.
by the
Well,
board of directors.
Well, the company's board.
If you say,
Yes.
you will, or the bank will say, yes, we are not going to take any action with regard to the forensic report against the directors unless there is an independent forensic report. Then the court can understand, yes, this forensic report only with regard to the company, there is no cause of action arose with regard to these petitioners who are the erstwhile directors. So there is no cause of action. No, but the bank will consider the only one forensic report and you have submitted only one forensic report. And in the one, though I have not gone into, but in the forensic report, there might be an allegation. These directors have siphoning off or misappropriated the amount as a director.
Yes.
As a director. So once the forensic audit report is under challenge, so where is the you can say that the petitioner's cause of action has not arose once the forensic audit report involves the directors. So where is another writ application?
Well, I'll tell you, Lordship, if they say the forensic auditor's report involves the director, so there has to be some allegation in the writ petition.
That's what I'm telling. With regard to the allegation in the writ application, that is different thing. That is to be decided at the time of merit, whether they have taken the plea, whether there is a pleading, whether they have justified with regard to the grounds which have. That is the merit of the matter. Now, at this stage, addition of the party, court cannot go. Court only to see whether they are the necessary party.
Correct. So all I'm respectfully submitting is that, well, today that what fell from your Lordship, that is correctly, that if they have made out the case that the forensic audit report also, there are recordings in the forensic audit report, or there are recommendations, or there are observations in the report which relates to the directors, and the directors' rights are also affected. Well, the writ petition is absolutely silent on that. There is not a whisper in the writ petition. So, well, now their addition of party application is in the writ petition. So, in the addition of party application, you cannot expand the scope of the writ petition. Like, had it been there, they could have been implemented. So what I'm trying to say is that since it was not there, well, the question of deciding that at the time of final hearing of the writ petition does not arise. This is my limited submission to your lordship.
Deciding the writ petition, see, today only they are asking that, yes, the company gone into CIRP, so they wanted to transpose the petition number 1 as the respondent number 14. There is no difficulty. With regard to addition of the 2 directors, they admittedly they were the directors.
Yes.
Correct. Whether they have proved in the writ application or not, whether it is to an on merit, because you have to deal with in your affidavit in opposition with regard to the pleadings. If there is no pleadings, then at the time of argument only, where is the pleading with regard to the petitioner? So petitioner cannot maintain, then the court will decide whether the forensic audit report on this pleading the forensic audit report can be set aside or not.
So then, my lord, I'll tell you, lordship, my lord, then the principle of addition of party doesn't get satisfied. You can only get added if your presence is required for adjudication or your rights are affected.
Correct.
Well, if your lordship recollects that Mumbai
Correct.
International Supreme Court has said, when can a party be affected? If today your rights are affected by this writ petition, well, then you can say that I can be implicated.
That's why the prayer A and prayer B, which you indicated.
Yes.
A and prayer B is the main prayer.
Yes.
Prayer A and prayer B with regard to the setting aside and quashing of the
forensic audit report.
And their right has been affected from the forensic audit report. That's what I'm telling. If you are the forensic audit,
correct,
you have to justify with regard to your audit report.
Yeah.
Correct.
Right.
Now, if the bank today say, no, they are not going to take any action with regard to the forensic audit, they will be out. Let this say the bank, they are not going to take any action against the forensic audit.
I am not on that. I am not on that. If today bank says,
no, why the forensic audit?
for
Why
the
forensic audit?
Because the account was red flagged
Correct.
under the fraud circular.
Correct.
And it is a statutory under the RBI circular, it is a requirement in law that the bank must conduct a forensic audit of any account which has been flagged as a red flagged account.
Correct.
It is a statutory requirement now.
Correct.
So that is why the forensic audit
Why
report
it
was
is statutory? Because unless and until the forensic audit will not come, so bank cannot take the
further steps.
Further steps.
Absolutely, madam. Absolutely.
Once you file the forensic report, what
Correct.
is the further steps? The so-called notice is to be issued if
Right.
satisfied by the bank
Right.
with regard to the forensic.
Absolutely.
If
Absolutely.
the forensic audit report reveals that there is a siphoning of misappropriation, whatever it is. So to whom the notice will be given? Company as well as the directors who are involved in the forensic
No,
audit.
my lord, the moment the notice is given to the directors, like in willful defaulters, your lordship has seen, in willful defaulters, each director has a separate cause of action, either they file jointly or they file separately. Similarly, situation here, the forensic audit report, but the situation is one and the same. If their rights are affected, I don't say that they cannot bring an action challenging the forensic audit. If it is permitted in law, they will. What all my submissions is restricted to the fact that not in this writ petition. Only on that not in this writ petition. That's all.
Okay.
And my lord, so far as the 2 CAN application is concerned, my lord, allow us to, because since your lordship can understand. Yeah, these 2 CAN application allow us to use formally an affidavit. So the first thing I said that I want to file an affidavit because your lordship can understand this is a big account. It's a 1100 crore was due in 2023. And well, multiple proceedings.
So what is the stage at this is whether bank has taken any steps?
My lord, if Mr. Bose is finished, my lord, if Mr. Bose has finished, he is not the lender.
Opponent number 11.
Who are you?
Union Bank of India.
You have taken any steps?
My lord, we have got a recovery certificate from the
in terms of
recovery tribunal, and we are.
Leave aside recovery tribunal. Are you have taken any steps on the forensic audit?
My lord,
we are going to
any bank has taken any steps?
My lord, the difficulty.
My lord,
the company is in CIRP, and the character of the directors has ceased. They cannot be treated as a director.
they can at best, they can say that they are the guarantors. They
May I
cannot,
update your lordship?
because all the directors are the guarantors.
May I update your lordship, my lord, if your lordship permits me? My lord, the bank, on the basis of this fraudulent fraud report, on the basis of this fraudulent fraud report which Mr. Bose's client has prepared, they've
Mr.
got.
I can only
Yes,
say
sir.
one thing, Malad, there was a CBI raid last week, apparently.
They have lodged an FIR against me on the basis of this report.
Mr. Thacker,
Yes,
why you're not
filing a
withdrawing
separate
the said and to take appropriate steps according to
who
file a
stops him?
separate, whatever it may
Who
be.
stops him?
Because
Mr. Bose, I can't hear, my lord, please. I'm sorry, my lord, I couldn't hear your lordship. My lord.
I am telling, so why you're not withdrawing this? Because see, now the petition number 1 is in CIRP. So petition
Yes.
number 1 cannot maintain the writ application, correct?
Yes,
And the
yes.
petition number 2 is there, the other directors are not there. And the pleadings is not with regard to the directors, pleadings is with regard to the company only. We kindly see the pleadings. What the Mr. Bose has raised the objection. The pleadings in the writ application is not with regard to the directors. So how okay, if today the court allow also, so how you can maintain the writ application? Then again you will come with the certain application for amendment in the writ application, amendment in the prayer and all the things. That again it will create the already there. I think this 5 volumes is there. Then again the further 2 volumes will create. So why you are not withdrawing this and file appropriate?
Rather say they are losing
Huh?
time.
Yes,
Yes, my lord. Now, my lord, may I tell your lordship, my lord? Writ application was filed on 27 January 2025.
Correct.
Over a period of 1.5 years, these 13 respondent banks have taken time to complete pleadings. Now,
Correct.
finally, pleadings have been complete.
Correct.
Now, I am taking the risk, my lord, as being one of the petitioner. I will not file any amendment. The writ is ready for final hearing before your lordships. If your
Okay.
lordship feels that the petition does not make out a case, I run the risk of dismissal. It is not for Mr. Bose's client or the other bankers to advise me what is to be done, my lord.
That's why I told to Mr. Bose, because
Yes, I will decide, my lord, on my writ petition. If it survives, it survives. If it fails, it fails. 1.5 years they've dragged this proceeding. They don't want your lordship to hear the matter on merits. And because of this delay which they have caused, FIR has been filed against my client, the petitioner number 2, as well as the other directors, which sets out the fraudulent report prepared by Mr. Bose's client. That is my urgency. Kindly see, my lord, only 4 dates your lordship kindly makes a note of, and then I'll trouble your lordship with the papers. Kindly make a note of only 4 dates, please, my lord. 4 dates and 4.
And with regard to the item, the CAN 3, you paid for the transposition of the respondent petition number 1 as 14. How the 14 can, unless and until he has been substituted.
Really?
No, he's a company. My 2 is for his substitution. 2 is for bringing in the RP.
Company is in CIRP, how the company can be transposed now? Unless and until RP come on the issue of the company.
RP has been served, my lord. That is the CAN 2 to amend, bring in the RP.
He has come and with the smile face, he stated that he will take his instruction. Today also he is smiling, but he's not.
I am here, my lords, with respect to the RP, my lords. Because since CAN 2 is available with the my lords for substitution, my lords may allow me, I'll file my wakalatnama and will proceed, my lords. Because since I have taken an individual forensic audit report as per the IBC, I have already filed a PUFA application before the NCLT, my lords. So there is a separate proceeding as per IBC is going on, my lords.
IPC is not concerned.
IBC we are not concerned with. My lord, if your lordship so desires, kindly strike out the name of petitioner number 1 also. There's no difficulty. Now that he's in IBC, I thought only because he's as Mr. Bose advised us, he might be a proper party. That is why transpose him. I'm learning. That is why proper party you can transpose him. Otherwise you can strike out also. There's no difficulty.
Because my lords, on the last occasion, my lords has directed me to get impleaded as and file an application. Since CAN 2 is available before my lords, so straightforwardly CAN 2 can be allowed. I can be on record, my lords. Because there are similar application would be, if I am going to file an application, that would be similar to the CAN 2 only.
Yes, ma'am. CAN 2 was first bringing in the RP, and now, my lord, CAN 3 for the sake of completeness.
Now, Mr. Bose wanted to file affidavit in opposition with regard to the CAN 1 and CAN 3.
My lord, these applications were served long and kindly, my lord.
This
appreciate my urgency, my lord. My urgency is that this.
How soon you will file?
Maybe a week's time.
My lord, may I place for this, my lord, if your lordship only considers, kindly keep can 1, can 2, can 3 all on the side. Kindly only consider the petitioner number 2 is there. He is not running away. Kindly hear it only for the petitioner number 2. If the other directors are implemented, they will get the relief. Otherwise, they will not get the relief. Well, there is some urgency. Otherwise, I would not have made this kind of a submission.
Unless and until, because this three applications is not disposed of, how this court can proceed with your only petition number 2? That's why initially I told first the writ petition is to be informed. Petition number 1. Petition number 1 has to be either deleted or to transpose. Then the RP has to come in picture. Then and you tell that if you're not pressing the petition number other directors, then I will proceed with the writ application.
Well, other directors also
pending the application. How the court can take the writ application part by part?
Well, may I submit this?
Tomorrow I dispose of the application and the other directors will engage another lawyer. So pending that, pending my application, writ petition disposed of on behalf of the petition number 1.
Well, the lawyers are the same, my lord. There's no difficulty there. That apprehension will not be there, my lord. We will not mislead the court at any time. And all that I'm saying is, my lord, kindly, as far as the RP has submitted, can 2 can be allowed. Can 2 can be allowed. RP says he can be substituted. Now, transposition, my lord, I am the petitioner. Your lordship knows the principle.
Cannot be allowed with can 2 with regard to you are also made some amendment in the can 2. You made the amendment in the can 2.
Amendment is can only for the pay, only to name, only the name, my lord. There is no amendment on merits. I'm not changing the pleadings at all. Kindly see the limited scope of amendment, my lord. Your lordships in the writ court, my lord, this is not a civil court, and even if it was a civil court, your lordship knows dominus litis, my lord. Petitioner has the right of carriage of proceedings. Here, a respondent is hijacking the proceedings.
That's correct, but you are making one or the other application by making a complicated of the matter. Otherwise, the matter
only because of passage of time, man. Only because of passage of time.
Simply deleting the name of the petition number 1, you can carry out the petition. There is no difficulty. Now you file the let the file the affidavit. How soon?
Only because
1 week. 1 week.
Yes, Mr. Thakur.
1 week.
My lord, I'm only submitting this. I'm sorry for repeating, my lord. I never do this. My urgency is this, my lord, that on the basis of this forensic audit report, which is pending for challenge, your lordship, I can only decide on the validity or otherwise of the forensic audit report. Nobody else can.
I am agree. I will fix tomorrow, day after tomorrow, whatever. First, you say whether you not press the can 1, 2, 3, and I will delete the petition number 1 and I will proceed with the matter. There is no difficulty. You know this court. I am not worrying about the matter.
I know, man. Kindly allow can 1, 2, 3 today.
So can 1, 2, 3 cannot decide when the other party want to file affidavit. The court cannot curtail the liberty.
My lord, may I submit this?
You have any urgency? If you want to not press, you not press. I will fix the date on next week. I will hear you. No problem at all. If you want to should follow, then the other side wanted to file affidavit, then opportunity is to be given.
My lord, may I submit this? My lord, my respondents have no right to object on addition of party.
Maybe object or not object, but they wanted to file affidavit that the court cannot restrain. The court cannot so much decide whether it is they are entitled to get a file affidavit or not. The petition has can number 1, 2, and 3. The respondent number 13 prays for time to file affidavit in opposition. Let affidavit in opposition be filed within a week. Reply, if any, thereto within 1 week.
My lord, no reply, my lord.
Within a week, police of the land council for the petition submitted, he will not use any reply. Let the matter appear on. Let the matter appear on 5th of August within 10 matters.
Lord, there is no cause of action as
My lord, yeah.
for 11.
Under
My lord,
under
will be given to file affidavit respect of 1 and 7 as well. Respondent 1.
respondents
All respond. My lord, may I just request for this?
affidavit in opposition filed by the respondent director to file affidavit in opposition with regard respect of the can 1, 2, and 3 within a period of 1 week after serving the cooperative land council for the petitioner. Petitioner submitted he will not use any affidavit in reply. List the matter on 5th August at within 10 matters under the same heading.
My lord, may I just pray for an earlier date, my lord, if your lordship's board permits, my lord. If your lordship's board permit, my lord, I'm giving up my right to file reply only for an early hearing. If your lordship's board permits, my lord, an earlier date. Only if your lordship's board.
1 week. So 30th is the 1 week. 31st is the 1 week.
Kindly
Very
keep them
well.
to
I'm
6th.
sorry.
6th.
So 3rd or 4th, because my diary might be 6th.
6th. Well,
Come on 4th.
Fourth, please, my lord. Fourth. Grateful, my lord.
On 4th.
4th. Very good.
4th within 10 matters.
4th.
I'm so grateful, my lord. Grateful, my lord.
Yes, next.
Customer matters fixed at 1 p.m.
We have consulted, my lord, the original document proposed,
I-
my lord, handed over.
Yes.
My lord, out of 8 set of original documents, my lord, 2 documents were not given. One is MDMS degree certificate in original, MDMS mark sheet. That those 2 documents are still, my lord, withheld by the authority.
My lord, by the university, my lord, not the authority.
So that's why I kept this. I know.
Comprehensive. My lord, that's with the authority.
Who is appearing for the university?
168 again?
Yes. What about the document?
Yeah, 172. 67 টাকা
না না এমএস এর এমডি
Which document?
যেগুলো আমাদের কাছে নেই
MDMS
রুকো না।
degree certificate and mark sheet.
All.
Yes.
All petitioners. Degree certificate and
Mark sheet.
that has not been given.
No.
With regard to the BDS, MBBS,
MD and MS.
MD and MS.
Final degree and
Yes.
that will be provided after this competition is over.
What?
This,
The board has passed an order, bring all the original certificate. What original certificate? This is with regard to your examination. Not, so they will provide. This is with regard to the what the original you have submitted, that is.
Now, my lord, only one thing, my lord. Well, I'm very sorry to disturb you in third place, my lord. Only one thing, my lord. Kindly indicate that those documents are lying.
University, not for
University may be directed, my lord, to provide all the documents, my lord.
The pass certificate will be given to the
What certificate?
MD passing certificate.
Pass certificate.
Degree
Degree certificate.
certificate and mark sheet.
Degree certificate and mark sheet.
Yes.
Go ahead.
In terms of the order passed by this court, the respondent authorities have brought the original educational certificate of the petitioners, and the petitioners have verified the certificates brought by the state. After verification of the said certificate, the petitioner find that all the original certificate is available, except the except the final year, except the except the degree of degree of MD/MS and mark sheets. Learned counsel appearing for the university submit that the university will provide the degree as well as the mark sheet of the petitioners within period of
Within 1 week.
within a period of
Less
1
than
week. Within a period of 1 week. Full stop. As the petitioners are satisfied with the document produced by the state authorities, accordingly the state authorities have handed over.
Yes, no, that is in the envelope.
The state authority, the petition has handed over the original document to the learned counsel for the petitioner. The learned counsel for the petitioner shall provide the acknowledgement of all the original certificate to the learned counsel for the state, and a copy be kept with the record.
Yes, my lord.
Copy of the acknowledgement be kept with the record. The university is directed to supply to provide the degree and the mark sheet of the MD/MS to the petitioner within a week from date. WPS
In the course of
yes, today.
Much obliged.
Unless and until not to give, otherwise they will not provide you.
Much
Yes.
obliged.
Just go. Next.
Your Lordship, item 14 is also an SIR matter.
Yes, with
My lord, item 72 is also an SIR matter, my lord.
Yes.
Usual order without giving any time frame, Your Lordship, because it will be done immediately. I've already forwarded his petition.
Same. The petition has filed the same one. Enough time is required or 1 week.
Urgency, kindly record
But
the
that's
urgency that.
The petition has filed the present writ application, praying for a direction upon the SIR tribunal for disposal of the appeal dated 31st of March 2026. Counsel for the petition submitted due to deletion of the name of the petitioner from the voter list, the passport authorities are not renewing the passport of the petitioner. As such, unless and until the appellate authority will not decide the appeal, the petitioner will not in a position to get the passport. He prays for direction upon the appellate authority for disposal of the appeal. In view of the submission made by the counsel for the parties, the writ petition is disposed of by requesting the appellate tribunal to dispose of the appeal of the petitioner being appeal number AP, dispose of the appeal of the petitioner dated 31st of March 2026, preferably within a period of 2 weeks from date.
I've already forwarded, it will be done immediately.
Within a 1 week from the date of receipt of this order. Within a 1 week from the date of receipt of this order. इसको अलग से टाइप करना, पिछला बार छोड़ दिए थे, इसको अलग से टाइप करना. Yes.
Your Lordship, item number 72. This is adjudication case.
Just a minute. Yeah, yes. Somebody is telling
My lord,
7.
I am appearing, my lord. My lord,
Yes.
it was earlier heard by your lordship, my lord.
This is also
My lord, this is also an SIR matter, my lord. This is also a SIR matter.
17.
72, my lord.
72. Yes, call the fixed matter. 72.
72 is the issue wherein still their application is shown as adjudication. It is pending before the administrative side of our Honorable High Court for consideration because it was done in terms of Supreme Court's order and even our High Court is involved in it. Certain judicial officer had not put their digital signature in the orders. As a result of which it is pending. It is pending for our registrar. It will be considered. Kindly give us further 4 weeks time.
You are appearing?
No. But if the petition is appearing online.
My lord, I am appearing virtually, my lord.
So
This is a matter, my lord, your lordship has already considered that today is fixed for filing a report for them by them, my lord.
But it is registrar for
my lord, so for my instruction, my lord, this was actually originally for the unmapped, my lord. First unmapped, my lord. The appeal before the DEO was pending. During the pendency of
but the appellate authority, the adjudicating authority has not signed the order.
My lord, my case was never sent to adjudicating authority, my lord, as per my instruction available to me, my lord, because it in my portal also it is not showing that it has gone to adjudicating authority, my lord.
Okay, I will take subsequently. Call the fixed matters. You give. Where is the appeal?
Scanned copy is yet to be served by my learned friend.
Yes, same order. Republic within 3 months. Yes.
Page 13. Page 13 is the appeal.
Disposal. Yes.
Scanned copy का दिए
But I am for the petition.
WhatsApp पे दिए Election Commission.
How many petitioners?
Well, there are 7 petitioners. I have given the 7 court fees also.
Where is the 7 court fee?
Yes, sir. Yes, madam.
To whom it is given?
Only.
Okay.
If only family members, then kindly permit. Otherwise, what is happening? They have.
Yeah, that's why I'm asking. They are the family members.
He has not
Yes, yes,
provided
yes,
the
yes.
scanned copy, Your Lordship. I have requested it.
Seven are family members.
Your
All are
Lordship,
seven
these
family
petitions may be taken up on Monday because I have requested my learned friend to provide scanned copy even yesterday.
All canned copy তোমায় দিয়ে দেবো।
দিয়ে দিলে পরে দিলে আমি কি সাবমিশন করব?
সব দিয়ে দেবো আজকে।
Now, if it not given, then I will not pass on because otherwise the
I shall. All
first pass over. 156.
54, 155, all are his matter till 166.
Till
Till
yes.
166, my learned friend's
You're
matter.
not scanned.
Not scanned.
Then what will come? 156 to 166.
66.
Yes. Not today. Not today.
Not today.
You first you scan it, come in. Otherwise, appeal will not dispose of. 54, 55 disposed of. Harko. 54, 50, 154, 155 disposed of. Now you come to 167.
167. 54 and 55 are also his matters, Your Lordship. He has not provided scanned copy.
I will not sign otherwise. You're not. Who is upon 54?
But I am the 54, 55. Last class I took from chamber. I should give all this.
The chamber you then you come on next Friday. Not auto mat karo. 154, 155 mat karo. Come 167. Morning hours you are mentioning and you are not scanning the matter. I will dismiss all the let you come. Yes, 167 who is appearing. None appears on behalf of the petition, no petition, none moved, dismissed.
168 to 172, again my learned friend's matter.
Not all the scans of
166, 68 to
172.
172, not today.
Lord, 173, I appear for the petitioner.
173.
Lord, page 16 the appeal. Lord, there is some urgency. I tell you, Lordship, what? Lord, yesterday there was a meeting for election of Pradhan. I was to be elected. Lord, saying that since my name is deleted from the list, I should not be elected. But the other coordinate bench has granted stay since I could not get an order from the appellate court. Kindly direct me the matter is fixed on Wednesday. This is the order of the coordinate bench. But if it could be decided only this month, otherwise I will lose a democratic process. I have given my learned friend copies. Not only this, my appellate page 60, if it could be decided not before that. আর একটা কপি নেই অর্ডারে আছে তো কালকের অর্ডারটা
Shall not be held on 29 July.
they order and the matter is kept below, I believe, on 23rd or 29th. Yes, Tuesday. 29th ki
Yes,
baat?
till 29 July.
Yes.
Which appellate authority? Where?
No, page 60 is the appeal.
Page 60.
Yes. আর কাছে বল না আপনিটা দেখে briefটা দিন।
The petition submits that the petitioner is the member of the panchayat.
Earlier, yesterday was the meeting for election. He used to be elected. But I have the writ petition which has been filed.
No, he is the member as president.
Member, I don't know.
He was the Eastwell Pradhan.
She is the member, the erstwhile yesterday, the date for election.
No. The orders, 23rd July order of the Justice goes.
Yes,
the petitioner who is the erstwhile
I am
Pradhan.
the respondent there. I am not Akhtari Khatun. I am the respondent. I have been restrained from being elected. Because my name is
The petitioner is the member of the panchayat.
My lord.
Panchayat. But due to the deletion of his name from the voter list, the panchayat is going to take decision for
election of Pradhan.
For election of new. He is the member. You are telling me, Pradhan.
Yes, Lord. The members amongst them. She is the member. Now, yesterday was the date for election. She was to contest. A writ petition has been filed saying that she cannot contest since her name is
So, election of member or Pradhan?
She is already a member. She is already a member. Only from membership, Pradhan will be elected. I have to first be a member.
elected from them, they will elect.
She will contest as a Pradhan.
For the post of Pradhan. For the post of Pradhan.
Is a member. No, क्या बोला? Panchayat of the Pradhan. Now, Panchayat क्या बोला? Member of the Panchayat. The petitioner is the elected member of the Panchayat, full stop. Now the petitioner intends to contest the election of the Pradhan, but due to the deletion of her name from the voter list, comma, the authorities are not allowing the petitioner to contest the post of Pradhan. Accordingly, the petition will full stop. The petition submitted that the petitioner already preferred an appeal before the appellate tribunal on 6th of April 2026. So that 2026 and prayed for disposal of the said appeal as early as possible. If the decision will be in favor of the petitioner, comma, the petitioner will be in position to contest the election of the
My lord.
Further, consider the submission made by the counsel for the petitioner. This court finds that the petitioner already preferred an appeal dated 6th of April 2026, which is pending before the appellate authority. Accordingly, the SIR appellate tribunal is requested to dispose of the appeal as early as possible. When is the election?
Lord, it has been stated.
As early as possible, preferably within a period of 2 weeks from date.
Lord, maybe within 1 week, Lord, I
don't know, 1 week it can be done.
Your lordship. Your lordship.
Within a period of 1 week from the date of receipt of this.
I'm grateful.
Receipt of this order. Disposed of.
Yes. But in the morning, I could not appear physically.
No
Excuse me,
problem.
I was there.
I am not.
I tried my best.
This court is satisfied the lawyers appear through the virtual mode, but not with regard to the nuisance, sorry.
Yes.
Sometimes somebody will be in the car or sometime within the trouser only.
Absolutely.
That is never been permitted.
Absolutely.
But
always kind enough to allow
so I am welcoming with regard to yes, item number.
There's something for which I could not come to court.
Yes.
There is some urgency. Petitioner is a net qualified and he possesses a OBC A certificate. Belong from
Now the OBC is remains.
Yes, my lord. Central OBC list.
Just kindly record, he's a student and he requires his.
For the post of assistant teacher, sir, he need OBC A certificate.
So what post you are applied for?
Assistant professor, state eligibility test.
Assistant professor, you have PhD degree.
I have PhD degree. I am net qualified, my lord.
The petitioner submits that petitioner is having the PhD degree and also net qualified, but due to the deletion of the name of the petitioner from the voter list, comma, the petitioner application is not been accepted for the
Re-verification, my lord. Re-verification of OBC certificate.
re-verification of the OBC certificate has not been and has been held up. The counsel for the petitioner prays for a direction upon the appellate tribunal for disposal of the appeal as early as possible. Consider the submission made by the counsel for the petition. This court finds that the petitioner has preferred an appeal before the appellate tribunal. Where is your appeal?
My appeal is at page 32.
The tribunal.
P3.
P3.
Yes, my lord.
Appellate tribunal on 2nd April 2026, and the same is pending for adjudication. In view of the above, the appellate tribunal is requested to dispose of the appeal filed by the petitioner dated 2nd April 2026 as early as possible within a period of 1 week from the date of receipt of this order. Yes.
In 175, my lord, in 175, page number 21, petitioner is a BSF constable GD. Internal police verification is still pending. It should not be affected. It should not be affected due to relation from the electoral roll.
Probably within a period of 3 months.
Appellate.
Appellate page 23.
Yes, next.
6 minutes I have for the petitioners.
Well, appeal is at page 39. Well, they are the family members, brothers and wife.
Have paid the court fee?
No, my lord.
No.
No.
Then?
For the
My lord,
course of the day.
no, in course of the day, my lord, through online mode, my lord, e-pay, my lord, I shall pay, my lord. Rest to court.
I will not
My lord,
sign the order.
within an hour, my lord.
Earlier also one of the advocates that
My lord,
sent
within an hour, my lord, sir.
page number?
39, 41 and 43. Appeal was preferred on my lord 1st of April 2026.
Usual.
3 months, preferably within 3 months.
There's one matter in the supplementary list.
Appeal is page number 18, madam.
Yes.
Page number 18.
80.
18.
What is the urgency? You are from every day you are mentioning the what is the urgency?
Is the kidney affected? Is the kidney
Tractor driver? Huh?
Kidney affected. Kidney patient.
So?
This.
So what do you want?
He cannot apply the passport.
Kidney patient passport what will do?
Out of treatment for out of India.
India is the best place for the treatment of the cancer.
Like the eye treatments. The kidney treatments.
Lordship knows, my lord, this other outside treatments are much more.
Your lordship, usual order, because there's no document pertaining to.
Where is the document?
Medical documents की लगी है there's no usual order.
Preferably within 3 months.
Would your lordship, my lord,
Your lordship, with regard to item number 72, let it appear after another 4 weeks. Meantime, we are following up with the.
My lord, may I pray that, my lord, let this matter appear Monday, my lord. It's to be mentioned, my lord. I need to indicate that it was never gone for adjudication, my lord.
नहीं निकाले ना, नहीं मिला.
My lord,
छोड़ दो रहने दो.
Monday.
my lord, let it be there, my lord. Monday, my lord. I will try my luck, my lord. I need to indicate your lordship before your lordship, my lord.
supervises, my lord, kindly, my lord, mind to
Grateful,
forgive me. Is a kindly mind to forgive me, my lord, for this urgent mentioning.
Which one?
My lord, there's an unlisted, my lord, size. My lord, yesterday at 4 p.m., I was being served with a, my lord, a Shorai order directing me to close down my business within 3 days at 4 p.m. Well, during the midnight, well, when the candles were burned, well, the petition overnight being ready, it is already been.
Business you are run?
Well, it is a Shorai under the valid document, valid license passed by by an authority who didn't even possess of such such right under the Shorai Act. It is only the district magistrate. I have produced the entire documents. I was not given, my lord, any opportunity to file, my lord, any further clarification under the Shorai Act section 9. It shows.
Issue notice Monday.
Monday, my lord, only one more request, my lord. It is a top of the list.
Within 10 matters I am keeping.
May I say this? So 3 days it will be covered on Sunday. But Saturday, Sunday, Monday, if not being taken up, I am extremely grateful.
Notice, otherwise I will not.
I will leave file.
Leave granted. List on Monday within 5 matters. Directed to issue notice.
Extremely good.
It's urgent, my lord. Actually, some of the petitions are working on daily basis, and I have mentioned earlier, but date has been given on November, my lord. Kindly.
Give the number to my court officer, I will see.
Deeply obliged, my lord. Extremely privileged. Sir, it will leave my lord.
When I come, your lordship was calling the list, 3 or 4 like
The
that.
matter.
The matter is, I am a resolution professional. My assignment has been stopped. Why? And no order has been passed, only by the publishing in the website, when admittedly the matter brought in a subsequent application before the learned NCLT, and NCLT the so-called, actually the complaint made to the State Bank of India, then the so-called issued. I give answer. I have asked them for giving personal hearing. Nothing has been given. No reason order been published in the website, and in between, when the assurance given with the learned NCLT on 10th April and final order made by the NCLT on 10th June. In between, when they have published, I don't know, but new assignment when comes, they told me that you cannot take any assignment of us. This is the problem. Then I came to know. So what I am praying, subject to lordship kind consideration, I have not yet served, not yet filed, because I have to take leave from your lordship. And if your lordship granted me leave, then I shall serve them, I shall file it. Your lordship kindly give a date, early date, so that I can do my work.
Okay, liberty granted to list Wednesday. Wednesday within 10 matters. Issue notice. 29. Issue notice.
Yes, I shall serve. I shall file and I shall serve. My learned junior will accept.
My lord, I have mentioned the matter. Today it is appearing as item number 21. It was indicated by your lordship in the mentioning slip. I have mentioned a month back. My lord, it was indicated it will appear within first 10 matters. My lord, it is appearing
21. Let it wait whether.
My lord, on SIR matter.
No. Yes, call the list.
Item number 148.
Lord, so Dr. mentioned this in the morning.
Yes.
I was online. Lord, we have filed.
You are for the petitioner?
Yes, we have filed the opposition to the vacating application. Although a little late, Lord, was served on.
Lordship, I appear for respond number 124, Lordship. Lordship, instead of 24 June, they have affirmed and served me the affidavit in opposition on 21st July, Lordship. I'm seeking only 2 weeks time to file my affidavit in reply, Lordship.
Reply to?
Reply to their opposition.
Lord, they have filed a vacating application. My Lord has passed an interim order, Lord, on 5th of May. And Lord, they have filed an opposition vacating application, Lord, to the for seeking vacation of the interim order. Lord, we have used our affidavit. Now, Lord, if they use the reply, my Lord may decide the main matter also.
Main matter affidavit is completed?
No, it was not they.
Not filed?
No. Not filed.
And you have filed the application? Why your persons are not coming with the main application? Your main application can be treated as a double affidavit.
No, Lordship, let me come back with reply, Lordship.
The petition has filed affidavit in opposition in connection with CAN 1 of 2026 after serving the copy to London Council for the respondent. Council for the respondent number 5 or 124?
124, Lordship.
Council for the respondent number 124 prays for time to file affidavit in reply. Let affidavit in reply to the CAN application, CAN 1 of 2020. Let reply be filed within 2 weeks.
Within 2 weeks, Lordship.
2 weeks. Please the matter on. 21st September.
Lord, my Lord may keep it in on August also, Lord.
August, there is no date. Especially cannot fix. If you want, I fix on normal date.
Because I tell you, Lord, Lord, I want to do the job. They have terminated my contract. I have also written in my opposition that if I get 6 months time, I'll complete the job. So instead of keeping it in September, my Lord may keep it in August any day. I want to complete the matter, Lord. I want to do the job. Subject to your Lordship's direction.
Hey. 26th August at 12 noon.
But the interim order has to be.
Interim order is extended till the next date of hearing or until further order.
Lord, my Lord may record that if they wishes, Lord, in the meantime, they can also file affidavit against the main matter.
So the time would be shorter.
It is fine from the record that the respondents have not filed their affidavit in opposition to the main writ application.
Yes, the almost 1 month is in
respondents have filed their affidavit in opposition within 2 weeks.
Yes.
We reply if any thereto within a week thereafter. Yes. Call the list. Yes, sir.
So 2 weeks, 1 week, and matter will appear on 26th August. So, my lord, if the my lord has fixed it at 12.
12 noon. कोई ये अच्छे ना आंसर लिया कोई है ही नहीं. The matters listed as in the supplementary list, taking into consideration of the mentioning list dated 23rd of July 2026, wherein it is mentioned that the interim order is expiring today. But when the matter is listed as in the supplementary list and call the matter, none appears on behalf of the petitioner. Thus, no order is required to be passed for extension of interim order. Next. Yes.
On behalf of the state, my lord.
My lord, the last order, which was passed by your lordships, kindly take trouble to look into this order.
Yes, well, report.
My lord, actually the bank guarantee has already been forfeited and credited to the account of the department. And so the matter already has been shifted to the finance department. So my lord, department took some time to reconsider the conditions and the petition.
What about the other part? Hearing that there 4 and 5 points are there. Can you have a look to this? My lord, directly to coming to record not only bank guarantee. Kindly please come. The notes which I handed over to last time. The last page of the note. Which I have annexed the notes. Have you noted, my lord? Notes. Hand over on the last page.
Yes.
Now, after filing of the writ petitions, the respondents invited the petitioner for a discussion. They invited me. Discussion by later dated such and such. At 12 noon, the petitioner attended the said meeting, and before commencement of the meeting, the petitioner also clarified his position by later dated such and such. During the meeting, such and such, the petitioner was represented by his authorized representative upon furnishing a POA and the attendance also. During the discussion, the petitioner was advised to furnish his proposal for resuming calamity by lord. And the petitioner submitted his proposal on the same day by later his answer. When the petitioner four conditions. So, my lord, that is why I'm sorry.
Have you served the copy?
No.
So?
Here only not only finance, the other aspect is there. And on the basis of their representation.
No, see the report.
Reconsider, my lord.
Report on the, it includes everything, all points.
See.
Pursuant to the appropriate order, the petitioner representatives and such and the were carefully examined by the competent
Second page.
Second page. I'm grateful.
Report of on behalf of the respondent 1 to 7.
The proposal of petitioners.
Yes.
There was not unconditional proposal to execute the work in accordance with the accepted tender condition. On the contrary, the proposal sought executions of the work subject to several fresh conditions, including conditional timeline, linking commencement of the post-monsoon period until availability of the sand from such and such, New Kali, Purva Mednapur and others. Refund of the forfeited bank guarantee amount and subsequent subsequent fresh bank guarantee. Finalization of the terms and conditions de novo. The consideration of the royalty, etc., which were found to be contrary to the provision of NIS. After initiation of the panel election, the forfeited bank guarantee and due to remittance of the amount to the revenue unprecedented
I file a rejoinder here. I'll file a
File
rejoinder.
exception to the report. The petitioner has filed the filed report after serving copy to the respondent number 127. Respondents number 127 has filed report after serving the copy to the land counsel for the petitioner. Counsel for the petitioner prays for time to take exception to the said report. Let exception be filed within 2 weeks. 1 week.
2 weeks? Must be, my lords, my headache. 2 weeks.
2 weeks. 2 weeks. Release the matter on 19th August.
As your lords is my lord.
19th August under the same heading. Within 10 matters.
I'm grateful, my lord.
Thank you.
May I leave, my lord?
Yes.
जाने का अच्छा नहीं लगता है लेकिन
बैठिए
same position. Chalo.
Your Lordship, I appear for
May it please your lordship.
Your Lordship, I appear for respondent numbers 3 to 8, Your Lordship.
Yes. 3 to 8.
Your Lordship, we've preferred an appeal against Your Lordship's order. If Your Lordship can keep it.
What does happen? Stay.
Your Lordship, we filed
No,
this
no, they have
as
not
well.
served as a copy. Yesterday,
Today
it has been.
Any stay is granted.
Your Lordship, I'll just indicate the difficulty is that we had to mention it before the Honorable Division Bench and we got obtained the certified copy in our hand yesterday itself, which is why we were not getting it for almost a month. Your Lordship, we mentioned it before the Honorable Division Bench yesterday. We got the certified copy in our hand. It has been filed. I have the receipt with me, Your Lordship. Here, after this, we will file the stay during the course of the day or on Monday, Your Lordship. If Your Lordship can kindly give us 3 weeks time.
15, my lord.
Yes. So no, you're not done anything.
Nothing.
So it is your intention that instead of giving possession, instead of correcting the deed, instead of executing the deed, you preferred an appeal.
That's right.
So I am issuing the contempt notice. You get an order from this.
My Lord,
from the
just
appellate.
give me
Sorry.
time.
This court deprecated all this. This court has not passed any order curtailing your right.
That's right.
Kindly see the page, paragraph 15. Whatever the order is passed, subject to outcome of the
Your Lordship, the payment.
If you are not able to register the deed, if you are not able to correct the deed, and you are going to the appeal.
Your Lordship, it is only because the vacant flats, the maintenance are.
So yes, sir. The vacant flat, you have not sold the flat all. The 30%, 40% has been sold. Whether the person who have purchased the plot, whether they can give the other maintenance of the flat. Where is the rule?
Your Lordship, the general terms and conditions contain, it was agreed upon.
Total. They will pay the total if it is not sold.
That the housing board will not bear the maintenance for all the vacant flats.
Vacant flats, who will bear? Okay.
And my lord, what is more important, they have made a false statement the other day, my lord. The BMC, lordship will see water line connection. My lord, your lordship will see left hand side 100 dia water line BMC at the middle of the page, my lord.
Yes, yes.
And then bottom also 150 dia BMC. So connection is there. They made a wrong statement before your lordship, for which your lordship recorded that let it continue, etc.
No, that's why they changed the advocate. Before this court, every day.
Your Lordship, kindly allow me 1 week's time, I will come back, Your Lordship.
It is very difficult for the respondent before this court.
Your Lordship will allow me 1 week.
Every time the respondent changes their advocate. Court number 25, you go, you go. You go, you come.
Lordship issue a rule, so motor rule for contempt against the housing
Lordship will
commission.
allow me 1 week's time, Your Lordship.
1 week, madam. You tell me from your conscience what order the court has passed, so you are aggrieved with that. What order the court has passed?
And from 15th, my lord, they waited. 15th.
Your Lordship, we had applied.
Court is only the intention that they should get the possession and the deed be executed. That's
Your
all.
Lordship, we had presented.
With regard to whatever the other demand, that the law will prevail over that. If they will not pay the amount, then you take appropriate steps, whatever it may be. So why you are not giving the possession? You are not registering initially. Your other colleague has taken the plea that they have raised the objection with regard to the contents of the deed. Then this court has taken the burden of
Great trouble, your lordship took.
taken the burden. Then
Every
the-
point.
all the points has come. Then this court has sorted out that. Once the deed's condition has been sorted out, what remains? This court has clarified this point is to be dealt with this point is to be dealt with that. Then what remains? And you prepared an appeal. Okay, who has prepared an appeal? Who is the let come? Who is the authority?
Housing Commissioner. Housing Commissioner is the respondent.
Let the notice be issued. He appear before the court.
Your Lordship will grant me 1 week's time, Your Lordship.
You are not obtained the interim order.
Your Lordship will grant me 1 week's time, Your Lordship. Kindly, Your Lordship. We were handed over the certified copy yesterday itself, Your Lordship, after I mentioned before the Honorable Division Bench.
Respondent number 4, Lord.
It is submitted by the Land Council for the respondents number 128. 328 or 128?
328.
328. That they have preferred an appeal against the order passed by this court dated 15 June 2026. The further submitted, the appeal could not be mentioned before the appellate court as the certified copy of this order received by the Land Council for the respondents only yesterday. Police Land Council for the petitioner raised objection and submitted that this court has categorically passed an order for giving possession and also made it clear that giving possession of the flat will to the purchasers is subject to the result of the application, writ application. He further submit that in the order dated 15th of June 2026, this court has also clarified with regard to the conditions of the deed. But in spite of the said, in spite of correcting the deed, the respondents have preferred an appeal. Consider the submission made by the counsel for the respective parties. This court find that Land Council for the respondents prays for a week time to obtain order from the appellate court. For the interest of justice, the case is adjourned. Let the matter appear on 6th of August 2026 within 5 matters. Let the matter appear on 6th.
I'm grateful. I mentioned the matter yesterday at 3 p.m. They got intimation and today morning they have filed it.
Yes, next.
I'm grateful.
My lord, in this matter, my lord.
I will take the matter, my lord.
My lord, in this.
Yes.
There's an interim order which may be extended.
As per the prayer made by the counsel for the respondent, the case is adjourned. Let the matter appear on 7th August under the same heading. Interim order is extended under the same heading, and interim order is extended till the next date of hearing or until further order, whichever is earlier.
Yes, instead of 7, my lord, may it be on any time after 10th, my lord.
Then 12th August?
Very good.
12th August.
My lord, worship within 5 matters for worship's convenience.
Within 10 matters. Yes, next.
Oblige, my lord.
I am for the writ petition.
Item?
Lordship, I am for the respondent of India.
Lordship, I am
yes.
and apologizing your lordship for my yesterday's conduct.
Yes. What is the matter?
Lordship, I was to get the instruction from the. I got the instruction.
Got the instruction?
Lordship, they are waiting for your lordship's order. As per the instructions received, your lordship.
Yes, what is the report?
Shall I read, Lordship? Shall I read?
Yes.
With reference to trail, it is submitted that based on the observation of the Honorable Court in order dated 19th of June, in which order passed by learned NCLT Kolkata branch has been referred, wherein learned NCLT has observed that any change in the board
will be subject to outcome of this petition. It is submitted that at the time, the assessing officer was of the view that since there is dispute between the two factions of shareholder, an issue of shareholding was also in dispute, it is considered fit to reject the application for removal directors as it will alter the management of the company. Further, it is submitted that normally where there is a dispute between two factions of shareholders, the registrar of companies normally discourage the removal as it will change the status quo. However, since the matter has been given,
Petition has been given liberty to file a fresh.
the respondent will consider the removal if ordered by the Honorable Court or filing.
Yes.
So, Lordship.
You file it, fresh file it.
Yes, Your Lordship. There may be a direction. I shall be filing it fresh DI-12.
Okay, Lordship. Yes.
You file it, they will consider. In terms of the order dated 19 June 2026, the registrar of company has filed a report wherein it has been clarified that the petitioner is given liberty to file a fresh, and if the petitioner will file any application, the respondent will consider the E-form,
DI-12.
E-form, if DR-12, if any, filed by the petitioner in accordance with the provisions of the Companies Act. In view of the report submitted by the, in view of the report submitted by the ROC, the writ petition is disposed of, giving the petition by giving liberty to the petitioner to file a fresh application under DR-12, and if any application is filed by the petitioner, the ROC shall consider the same in accordance with law within a period of 2 weeks from the date of receipt of the application.
It is E-form DIR-12.
DIR-12.
Grateful.
Okay.
Grateful, Lordship.
We are for Union of India.
This is under the for the artificial the alternative reproductive conception through the process of IVF, Lordship. I'm sorry. Lordship, here the petitioner number 1, that is the lady, is aged about 35 years only. But there is a huge gap between his spouse. So the spouse is now aged about 64 years. So, Lordship, here we are not pressing for the gametes of the husband, Lordship. Lordship has passed similar orders, and also the Act provides that a single lady can
apply.
Yes, Lordship. Lordship, this is a similar order, Lordship.
Is there any report? She is fit to go for the IVF procedure.
The medical reports.
Yes, medical report provide that she is medically fit for the go for the surrogacy.
No, it is not the surrogacy.
Go for the IVF procedure.
Lordship, she is otherwise normal. Lordship, the
that's where is the report?
Reports are, Lordship, enclosed at page 27. Lordship will kindly consider these are the reports. It's annexure A5. These are the current reports. She is actually only 35 years old.
So why so difference of age?
Lordship, they have got married. There is a marriage registration certificate also.
30 years.
Yes. Lordship, at page 14, Lordship will find the marriage registration.
Where is the certificate? She is fit to go for IVF procedure.
Lordship, that certification is not separately there, but the clinic has been made a party also. Lordship, if that is required, Lordship will kindly take up page 25. It is written, attend IVF clinic. That was by the government hospital. It had been directed. Thereafter, they have approached. Lordship will kindly
attend IVF clinic.
Yes. Page 25. Thereafter, they have approached the respondent present.
So you do one thing. You
yes.
get a certificate for the present, whether she is fit to go for the IVF procedure. That is the better. Otherwise, tomorrow any complication will come.
She is within age. There is
age is not different with regard to the IVF procedure. Whether she is fit to go, it is not that only if the age is concerned. Whether it is the clinical report is required.
Lordship, I will.
When you will come? Yes. What is your
my lord?
What is your objection?
Give me
my instruction is that, my lord, they have come as a family, my lord, not separately.
If she had come separately, then it's a different thing. When they have come, the family.
Decided by this court.
Yes.
Even come together. But the one is the underage and so she can apply for it and it can be go. That is settled law. Justice Bhattacharya order. Have you gone through the Justice Bhattacharya order?
I have several judgments also. And
Several
also from
judgment, but the main
Kerala-
judgment is Justice Bhattacharya. That is, I think, you go through that.
Yes. I'm carrying a copy. I can hand over also.
That has
if
been
necessary.
relied by
Yes.
Justice Sinha.
Yes. And also
Your
the
Lordship, even the division bench had passed an order upholding Justice Bhattacharya's order,
yes.
but only as a wife, because as she is within age limit.
Yes, it's a vision, but I
Yes.
directed to come with the certificate whether she is fit to go for the IVF procedure or not.
Lordship, I can come with that.
When you will come?
Lordship will give me a week's time.
Week.
I'll come back with.
Land Council for the petitioner prays for a week time to obtain a report from clinical report with regard to the petitioner number 1. Whether he is fit to go for the IVF procedure or not. Let the full list of cases adjourned. Let the matter appear on 4th August.
Lordship, maybe before that, if there is one similar matter, Lordship has kept it on the 28th. I think
28 will get.
28th, I'll get it, Lordship. It is
28 within 10 matters.
I'm great.
Yes, next.
Your Lordship, I'm appearing for the petitioners. This is a similar matter under the Assisted Reproductive Technology Act. The petitioner, the wife is aged about 39 years and the husband is aged about 57 years, Your Lordship.
Wife is 37.
37, Your Lordship.
Yes, then.
Lordship, the ground for denying services by the respondent number 4, the IVF
Overage.
clinic, is the age.
Overage
Of the husband.
Correct.
But the wife is within the limit under section 21G.
But where is the certificate?
Your Lordship, if you have if you take page number 18 is the medical prescription. See, no significant at the bottom of the page, no significant past surgical history.
No surgical part.
And if you have, if your Lordship will take page number 23, this is a certificate issued by the clinic.
Yes, where is
This
it?
is to certify that Kumkum Samadar, aged such and such, wife of such and such, is unable to get IVF treatment because husband age has crossed the upper age. So this is the only reason that the services are being denied by the clinic. There's no other reason that the clinic has stated.
Yes.
My lord, that's the bar by the interpretation, my lord.
What is the bar?
Husband age should be 55 years, my lord.
Then?
My lord, as the lordship.
Yes, husband is 55. If husband is overage, what will happen? You have a judgment?
Yes, Your Lordship.
Which judgment?
Your Lordship's own judgment.
My judgment was Justice Bhattacharya order is there. Okay, give my judgment.
There's several judgments, Your Lordship. Your Lordship's judgment, para number 7, Your Lordship. 2026 SCC Online Cal 1500.
The petitioner has filed the petitioners have filed the present application, present date petition, praying for a direction upon the respondent number 4 to provide ART treatment to the petitioner number 1. Petition, full stop. Petitioner submit that the marriage between the petitioner number 1 and 2 solemnized on
12th August 2022.
12th August of 2022. And after the marriage, the unfortunate couple could not blessed with any issues in spite of several clinical tests. Subsequently, with the advice of the relatives and friends, and with the consent of both the the consent of क्या बोला? Subsequently, friends, comma, the petitioners have approached the respondent number 4 to adopt the ART procedure. At the time of clinical test, comma, the respondent number 4 found that the petition number 2 or petition number 1, the wife is aged about 38 years, but the petition number 2 is the husband of the petition number 1 is aged about 57 years. And as such, the petition number 2 is overage in terms of the act. Thus, the clinical authorities, respondent number 4, have refused to adopt the IVF treatment to the petitioner number 1 and directed the petitioner to obtain order from this court. Accordingly, the petitioner has filed the present writ application. The petitioner has relied upon the judgment passed by this court in the case of Rakhi Paul and another versus State of West Bengal and others, reported in 2026 SCC Online Calcutta 1500, and submit that the similar issue was decided by this court in the said case, and this court held that Section 21 within bracket G, the age of woman is prescribed shall be above than 21 years and below the age of 50 years, and for the men, the above the age of 21 years and below the age of 55 years. But this court considered that the wife is aged about 49 years, which is below the age of 55 years, and as such the court has allowed the wife to go for the IVF test and directed the authority to give the facility of ARTS to the petitioners. By referring the petitioner has also referred several orders in the case of Sudarshan Mandal and another versus State of West Bengal, passed in WPA number 9232 of 2024, dated 26th of April 2024, comma, WPA number 26524 of 2025, within bracket Vishwanath Bhadya and another versus the State of West Bengal, dated 6th January 2026, and Shamali Shah and another versus of the State of West Bengal and others, dated 22nd of November 2024. This court find that full stop. In the present case, Section 21G makes no difference between women and who approaches a clinic for taking resort to such technology individually and a woman who is one of the spouse of commissioning the couple approaching the clinic for similar purpose. The Act does not discriminate between the women who are married and those who are not. Such distinction cannot be made in the present case also. In the present case, the wife is underage and the husband is overage. Both the couple are ready to go for adopt for the ART procedure. But the wife is within the age limit, but the husband is within the out of the age limit as per the 21G II. Considering the above, full stop. In the case in hand, if the woman is not allowed to avail ARTS citing Section 221 within bracket G, even though she is eligible for the same, then it will be sheer injustice to her. For the ineligibility of the husband, the wife ought not to suffer. This is so because the husband has no physical participation in any of the procedure involved for the birth of the child through ARTS. The husband has claimed that full stop. The husband has, in the present case, the husband has given the consent to the wife to go for the ARTS procedure. Considering the above, the respondent number 4 is directed. Respondent number 4.
Yes, Your Lordship.
Respondent number 4 is directed to provide such facilities to the petitioner number 1 if the petitioner approaches the authority and the petitioner is otherwise fulfill the conditions except the age of the husband. The petition is postponed.
Your Lordship, may the affidavit of service be taken.
Next.
Grateful, Your Lordship.
But in 21, my lord, I appear for the writ petition.
Lordship, I beg to appear on behalf of the Union of India, Lordship. I am being led by learned.
My lord, upon service upon the added respondent.
Lordship, I am appearing for the Union of India. We are led by the learned ASG, Your Lordship.
Subject to what my learned friend says, may I only beseech my lord that may it be taken on Monday.
My lord, we are already under, my lord, because this is a question of infiltration, my lord, by a certain segment of persons, my lord, Bangladeshi citizens who have infiltrated India and have started a large-scale racket, one of which is, my lord, getting married to my client, my lord, falsifying his identity, religion, everything. My lord, I have documents, my lord, on record to show.
Lordship, we have sought instructions. Our instructions will take about a week to come, Your Lordship. That's what we've been told by the department. So kindly gives us some time, Your Lordship.
Authority, and my lord, at page 70, my lord, there is an FRRO report.
I am for the persons alleged against persons, for the private respondents alleged against me.
What is the matter? What is the prayer?
Yes, my lord,
Matrimonial dispute.
my lord, that is not correct. That is not correct. I'll come to the prayers. My lord, it is. I expected this, my learned friend, to say it's a matrimonial dispute so that, my lord, they can take this plea.
I do not want this to.
My lord, kindly have a look at the prayers at
Day accommodation, only a day.
36.
Okay, they are asking for
Lordship,
time. They are asking.
apart from that, also I am being led by learned additional solicitor general for the Union of India. Lordship, what I am saying is that if the copy of the amended writ petition be provided to us, because Union of India is like to conduct a prima facie investigation, cause an investigation in respect of the other families members are concerned. Lordship.
Yes.
And we'll come up with a report within a fortnight, Lordship.
I believe
Lordship, the amended writ has not yet been served to us, Lordship.
Basically, my prayer would have been.
My lord, I welcome it. My lord, let them come up with a report. Only prayer that I would place before Lordship is to, my lord, keep the matter in a position it will be taken up. This is extremely, my lord, and I am handing up the copy to my learned friend right now.
I don't. Whichever the matter is coming, this court is taking up.
I am grateful, my lord. That is, my lord. Yes, I am grateful. But only thing is, my lord, because it's a question of clear-cut infiltration.
You are appearing for state. AMC, yes.
He alleges that the petitioner is holding by wrongful means government documents and deciding it. Look, so far as is only one document, the birth certificate. But my records does not reveal that it is a true document.
Yes. Well, in fact, the police report at point number 3, which is annexed to my writ petition, corroborated.
This is my assertion and this is the only limited hope I have for the time being to trouble you back.
Yes. আমি দাঁড়া বলেনি ওনারা এখন মাঝখানে বলবো
Yes.
My lord, kindly has a look at page 44 along with what my learned friend submitted.
Yes, fine.
And my lord, I am just handing up this page. I shall show it too. This is there in the earlier writ petition also. My lord, this is the private respondent, so-called husband, not kindly sees my lord holding the Bangladeshi passport in his hand. My lord, we have put some other records also. They have Bangladeshi passports.
Kindly
other Bangladeshi
prayer me once.
And visa, medical visa to India.
Okay. Let the authorities file the report.
Yes.
Record and on.
Your Lordship, I appear for Election Commission of India. We will also file a report.
You will file report.
Very serious offense, Your Lordship, because entire investigation has to take place as who are the person who has issued these documents to them.
If you give the jurisdiction to me, then I will.
Yes,
Your Lordship, kindly hand it over to the CID, no problem. Immediately hand it over to the CID.
And Learned Counsel appearing for the AMC has filed the report. Let the same be kept with the record. Full list of Learned Counsel appearing for the. Who will file report now? Who will file report?
Union of India.
Lordship, Union of India as well as Election Commission, as Ms. Pandey has submitted.
The Election Commission of India prays for time to file report. Let the report be filed by.
Lordship, at least 3 weeks time.
3 weeks is
2 weeks.
2
by
weeks, Your Lordship.
12th of August 2026. Serving the copy to the Land Council for the petitioner. The petitioner is liberty to take exception to the report, if any, within a week thereafter. List the matter on 18th of August 2026 under the same heading. The petitioner is
Deeply obliged.
directed to serve the amended copy of the
Union of
petition
India, my lord, I just serve. I'll serve the rest.
Since I presume that these reports may involve my interest also, may I also have a copy of these reports?
Let them, if you have, and okay, serve the copy to the petitioner as well as the private respondent. And the petitioner and the private respondent are liberty to take exception to the report, if any.
My lord, the greatest of the humility, my lord, can it be on the first few matters first and matters second?
18 within 5 matters.
Grateful.
So grateful, Your Lordship.
Yes, next.
Lordship, this is a matter which is a tender issued by IOCL, Lordship, where tender has been given to favored truck owners.
Where?
Favored truck owners. So this is ideally a tender to take oil tankers from Jalpaiguri to Rangpo in Sikkim. And there are pre-qualifications for the tenders. I will just quickly take your lordship to the tender.
What? Tender is over.
Tender is over. The tender has been awarded. But what has happened is now it is extended. The tender is still continuing as such. But what they have done is they had a qualification that this is the safe axle weight which has to be maintained. Trucks are given which are above that weight. They say very well, the date for submission of tender is over. You change those details and resubmit it. The truck owners resubmitted. Even then, under the law, they are not qualified. But yet they are awarded the tender. I will just quickly place the tender document.
Who are you? You're the.
I have participated in the tender.
And you are disqualified.
Some of my trucks have been accepted. The others have been given to favored truck owners.
So what the repeat now? What will do? What remains in the repetition if the award is given, work order has been issued, and
Lordship, the tender work still continues. If your lordship comes to a finding that it is perverse and they are not entitled to be awarded this contract,
go for damage.
Lordship, kindly only for the whether there is perversity or not. Only to that extent, your lordship will just nudge me. Lordship will kindly take the tender document at page 38.
Before that, this writ petition has been filed a year back. It was moved last year June. If your lordship kindly sees that.
That's why seeing the writ petition, I ask what is the.
Yes, because there is direction of your lordship kindly sees that order of 16th of June 2025.
Yes.
The direction for filing report and exception. My report I have affirmed long back. There has been no exception as on date. This is my report.
Copy served. Private response
Copy not served.
Copy not served.
Private কথা বলছি
225. Have you served copy?
Yes.
Yes. A report actually supports us, so we are not really worried about it.
Private respondent. You file the affidavit, then you have to serve. Correct. So whatever. So.
Actually, will kindly take the tender document. Will kindly take page 38 of the petition.
Ready? Can be taken up?
Yes, we are ready with the matter.
Yes. Page?
Lordship will kindly take page 38.
Yes.
Your Lordship will find that this is the pre-qualification criteria.
38.
Yes, my lord. This is a part of the tender. This is a pre-qualification criteria. Your Lordship will find bidders must offer at least one own bulk LPG TT of capacity 7 to 7.5 metric tons on the closing date of tender. Bidders offering only attached truck shall not be accepted. Bidders must submit the following documents as minimum pre-qualification criteria for this tender. Lordship will kindly take the PSPO license, that's entry 3.
Yes.
Valid licenses from Petroleum Explosive Safety Organization PESO as an original closing date of tender for carrying LPG. Lordship will also kindly turn over the page at page 39. Your Lordship will find just 4 lines above that entry 2. Notwithstanding any other condition provision in the tender documents, bidders are required to submit complete documents pertaining to PQC along with their offer. Failure to meet the PQC will render the bid to be summarily rejected. IOCL reserves the right to complete the evaluation based on the details furnished by the bidder with or without seeking additional supporting documents clarifications. Your Lordship will find at page 38 the quantity which was given 7 and 7.5 metric tons. This is based on rules issued under the Motor Vehicles Act under section 58.
Later on, later vehicle.
I have disclosed both. Now there is a date of 2018 which is also relevant over here because trucks manufactured prior to 2018 could measure up to 7.5 metric tons. All trucks manufactured post 2018, they have only 7 metric tons as the safe axle weight. Lordship, the notifications are at page 164 and 168.
$164.
Yes, my lord. The first notification is at page 164. Your Lordship will find this is the revision of, it's dated 18th of July 2018. This is revision of safe axle weight for transport vehicles and enforcement thereto. Kindly take paragraph 2. The issue has been examined in the ministry and the revised maximum safe permissible axle weight for transport vehicles have been notified by the ministry order dated such and such 16th July 2018. A copy of the notification is enclosed as Annexure A. The notification supersedes the earlier notification dated 18th October 1996. Lordship will find that notification at page 166.
Yes.
Lordship will find an exercise of the powers conferred by subsection 1 of section 58 of the Motor Vehicles Act 1999 and in supersession of the notification of the Government of India in the erstwhile Ministry of Surface Transport, Transport Wing number such and such, dated 18th October 19, the Central Board hereby notifies the maximum safe axle weight. Actually, this is the maximum that they can have of, say, of each axle type in relation to the transport vehicles other than motor cabs, having regard to the size, nature, and number of tires as under. Lordship will kindly take entry 1.2.
7.5 tons.
7.5 metric tons.
Yes. Not metric ton, only tons. Metric ton will not come.
Yes,
it is on ton. Yes.
Lordship, this was the first notification which was given. Kindly also take the explanation right at the bottom of the page. For the purpose of this notification, tolerance up to 5% in the gross vehicle weight shall be allowed for the purpose of compliance of subsection 3 of section 30 of the Motor Vehicles Act. This is for penalty, 113 is that penalty. This was subsequently again modified on the 7th of August 2018. Lordship will find that at page 168. Lordship will again take paragraph 2. As a result of amendment in the notification dated 6th August 2018, all the vehicle models that have been type approved before 16th July 2018, Lordship will kindly mark this date. Approved before 16th July shall be allowed the revised maximum safe axle weight. The gross vehicle weight of the vehicle shall also be revised accordingly. Transport departments of the states may take necessary action to incorporate the revised gross weight in the registration particulars of the transport vehicle. Now, the relevant circular, your lordship will find at page 170.
7 ton.
Yes, my lord.
7 tons. So it
Yes,
is
my lord.
reduced.
It was reduced.
7.5 to 7.
7 tons. Lordship will kindly see after paragraph 3, lordship just below that table, after paragraph number 3 and before the explanation, the following paragraph shall be inserted, namely, the above maximum safe axle weight shall be considered for revising the gross vehicle weight of the vehicles subject to overall limits specified in paragraph 2 for the existing vehicle models that are manufactured in accordance with the type approval certificate granted prior to 16th July 2018. Lordship, the reason I bring this to your lordship's notice is the trucks provided by me are all prior to this date, 16th July 2018. They are all of the year 2012. I will just bring it to your lordship's notice from the documents. I have enclosed the truck details. Your lordship will find the truck details at. Lordship, you will just give me one moment. Lordship will find it at page 111. I'm sorry, my lord, at 113. Lordship will take page 113. Lordship, all of them have a year of manufacturing of January 2012.
113.
Yes, my lord.
Yes.
These are the trucks which have been provided by the petitioner. All of them are manufacturing date 2012. So this is prior to 2018. Whereas the trucks which have been provided by them, the lordship will find at page 1.
It is your truck.
These are my trucks.
Page 113.
113 is the petitioner's trucks. The respondent's trucks are page 150 and 159.
150.
Yes, my lord. There are 5 trucks, 3 are in 150 and 2 are in 159.
159 is of
Lordship, all February 2024.
159 and
Lordship, 150.
These are the private respondents.
These are the private respondents. Trucks provided by the private respondents.
24. So your case is that if you're 12, you are of 2012, the 75.5 will continue.
Continue.
And
but as far as they are
2024, then it has to be to 7.
Lordship, what IOCL has done, they have gone a stage further. They, the original bids submitted by these truck owners, 7 and 8, were for 7.56 metric tons. Subsequently, they are allowed to revise and make it, and they make it into 7.32 metric tons. They are still not qualifying under this 2018 notification. I will not trouble your lordship with the writ petition because this has been admitted in the affidavit in opposition. So I will straight away take your lordship to the affidavit of opposition. Lordship, this is the report in the form of an affidavit by the respondents numbers 2, 3, 4 and 5.
Yes.
Your lordship will kindly take page 2, paragraph 2. Has your lordship got it? Okay. I say that the writ petitioner herein in the instant writ petition has sought to challenge the letter of acceptance issued in favor of the private respondents, being the respondent number 7 and 8, in the writ petition in connection with the tender being tender reference number such and such, inviting quotations from experienced resourceful bidders for bulk LPG transportation contract in tank trucks capacity of 7 to 7.5 metric tons by road from Raninagar LPG bottling plant, BP Jalpaiguri, West Bengal, to Rangpo LPG, BP Sikkim. The ground of challenge is that the payload capacity of the tank trucks offered by the said private respondents exceed the limit of 7 to 7.5 metric tons as stipulated in the caption of the tender inviting notice. It has been further alleged that despite submitting a license to transport issued by Petronas showing authorizing carrying capacity of 7.56 metric tons. Subsequent to the closing date of the tender, the private respondents have submitted and modified license showing the purported capacity to be between 7 and 7.5 metric tons at a belated stage, which according to the writ petitioner was in violation of the notice inviting tender. Lordship, the original licenses we have also disclosed. They are at page 153, 155 and 177 of the writ petition.
153.
153, my lord.
7.56.
Lordship will find at page 153.
The peso license.
Yes. These are the license which was submitted at the time of submission. Your Lordship will find the 8th entry, which shows the authorized carrying capacity of the container 7.56.
Correct.
So it's more than this. This is the document which they have submitted. Your Lordship will also get it at page 155. This is for another truck which has been accepted.
Yes.
Lordship will again find the truck number is given WB23G0373. The quantity is 7.56 metric tons. And also at page 177.
Yes.
Lordship will again find it is of 7.56 metric tons.
Yes. How much time will it take?
Lordship, not more than 10 minutes, maximum 10.
Come tomorrow. Record a note.
Lordship, in the meantime, the private respondents may serve the affidavit.
So. Now, counsel for the state has filed affidavit, respond number 2, 3, 4 and 5 and the respond number 7 and 8 have filed the affidavit. After serving copy to the counsel for the petitioner, let the same be kept to the report. Counsel for the petitioner argued the matter at length, but due to considerate time, hearing could not be completed. Let the matter appear on. Yes. 7th of? Let the matter appear on 11th August. Within 10 matters.
Before my lord, may I have a lord's leave to mention a matter before my lord takes the original side minute. The item 146 minute with the interim order is to expire today minute. That I've served notice on the other side minute. May I just beseech my lords to extend the interim order and keep the matter anytime. I'm ready with the hearing minute. All pleadings are complete. May I hand over the copy of the order and with the notice.
Record an order. 140?
146 minute.
Though the matter is listed as item number 146 and days list, but due to paucity of time, the matter could not be taken up for hearing. Let counsel for the petition mention the matter after notice to the respondents, but none appears on behalf of the respondents. Counsel for the petition submitted the interim order till today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 26th of August 2026 or until further order. Let the matter remain in the list.
Item 130, I'm praying for a similar order, my lord. The
130.
respondent is appearing, my lord. Yes, I'm.
Who is for the respondent? Yes.
My learned senior friend is there.
I'm deeply.
I was trying, he's there, my lord. I was trying to mention in the morning because he has some personal difficulty in the second half. So I was trying. Otherwise, your lordship's procedure is, my lord, at rising.
Similar. Item number 30. 130. Record. Though the matter is, still same. Matter remain. Breaking the same.
Only thing in the previous order, the respondent does not appear. Here.
So respond appear.
Your lordship, with your lordship leave, you may have mentioned item number 534, your lordship. I'm praying for CM, your lordship. My interim order is expiring today, your lordship. I'm mentioning upon notice.
150, 500?
534, your lordship.
504?
534, your lordship.
534?
Yes, sir.
Monthly list.
Yes, your lordship, monthly list.
The matter is listed as item number 534 of the monthly list, but due to paucity of time, the matter could not be taken of hearing. Counsel for the petition mentioned the matter. 26th August. 26th August. Supplementary list. But you have not appeared. You have not given to the supplement. You have mentioned tomorrow. Yesterday you mentioned.
Your lordship.
Have you mentioned yesterday?
Your lordship,
And today you find the supplementary. I have not extended the interim order. So see, supplementary list. I have taken call the matter.
1675, your lordship.
Yes.
1675.
My officer has went to your office also to search you. You have mentioned yesterday by mentioning list, informing that.
I handed over the slip, your lordship, because I could not
Yesterday you mentioned.
Yes, your lordship, but I didn't get the turn to mention. I handed over the slip to the officer, your lordship.
Today I mentioned the matter was listed. You not appeared. Now I've already passed an order. उसी में कर दो ये वाला supplementary में देखो
I apologize, your lordship.
जो supplementary छोड़ दे the matter is listed as in the supplementary list on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted the interim order still today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, the interim order is extended till 27th of August 2026 or until further order. Let the matter remain in the list.
I apologize, your lordship. Grateful.
Lordship, may I mention the matter?
Appellate side.
There's no urgency in the matter. This matter can appear on Wednesday.
Which matter?
The matter is filed today. It's got the number today. I'll tell you, Lordship, I am a lessee, purchased the property, got the property on lease from Kolkata Port Trust, given possession by Kolkata Port Trust, started working on that plot of land. It's just opposite this High Court pillar. Now the army comes and says, this is my property, no written notice. The railway comes and says, this is my property, no notice. And I'm now being threatened to be dispossessed without any notice, any writing, nothing is done.
So what the port authorities are telling? What the port authorities stand?
I have made them a part. They have given me documents to show that they have a right over the land and army. It's a fight between three government officers and I am sandwiched in the middle.
Tuesday within 10 minutes.
I'll serve all them.
Serve the Tuesday within 10 minutes.
My lord, the last appellate side matter that your losses has taken today, your losses please to fix the matter on 11th of August, my lord. But I have some personal difficulty and my son's admission is on that day. My lord, if your losses may kindly fix it either on 10th or 12th instead of 11th.
12th. वो जो है ना
22.
उसको inform the
I will inform the petitioner. Grateful, man.
My lord, may I mention original side?
Original side.
May I have your lord?
Original side. Please wait. लेके आना
I'm mentioning item 13 of your lordship's list, my lord. It is a part heard matter. Your lordship heard the matter several occasions. It is that matter, my lord. The flat in question was requisition and the change of the panel, my lord. That will be urgent. And your lordship kindly fix any date, my lord, so that time, my lord, so that it can be heard, my lord. Subject to lordship. And I'm mentioning upon notice on it.
Though the matter is listed as item number 13 in the trace list, but the matter could not as parted matter, but the matter could not be taken of hearing. Learned counsel for the petitioner place for fixing a specific date and time. And accordingly, case adjourned. Let the matter appear on at a date then. हाँ पहले नहीं है अगस्त में कुछ नहीं है full. Then you will go to September. 2nd September. 2nd September at 3 p.m. 26th August as 3:45.
3 p.m. because there is chance of.
Then come on September.
September 3 p.m.
3 p.m.
3 p.m.
2nd September 3 p.m. Okay.
Item 30, isn't it?
Yes.
Notice
I beg to mention a matter for leave for applying certified copy. The order and judgment passed on 8th July
Ah.
26.
Ah.
It is already past 1 week, so
Ah.
for leave granting.
What leave?
Certified copy.
Apply for.
No, the department is saying you need to take the leave of the.
You should have mentioned drawn up and complete, not
Draw and complete. Okay. What is the suit?
It's a writ.
Read also draw and complete. I don't know. Who told you?
The department is.
No. What you applied for?
For draw.
Draw. How you can draw in the writ proceedings? No, you applied for a certified copy, you will get.
My lord, the department is asking.
What you applied for?
For drawing up and complete.
Drawing and complete, you will not get. Certified copy of the order dated so or judgment dated so and so. Yes.
No, I'm not mentioning. No, not mentioning.
Item 185, Milord, of today's list. Milord, this is Milord, the interim order is expiring today. Milord, one more prayer with this. Milord, on second occasion on 10th of June, Milord had extended the time to Milord discovery of the inspection and document, all those things. Milord, we have discovered, Milord, given offered inspection not being taken. Now, Milord, they had 1 month back, they had sent us a letter saying that we are railways, we are outside, we need more time, 24th June, exactly 1 month. Today we are on 25th July. So, my lord, will kindly, Milord, extend the interim order and Milord keep this suit for Milord because my affidavit document.
But where is the other side?
I am mentioning on his.
Your Lordship, I am
Defendant number 2, Your Lordship. I beg to appear online, Your Lordship. I apologize for appearing from the car, Your Lordship. I appear for defendant number 2, Your Lordship.
I'm led by Mr. Shonak Banerjee.
Yes, so
my lord, this is my affidavit of documents.
So if you will not discover an inspection is not
stuck.
You will not discover the document, then I will close this.
Lordship, I appear for Lordship. The defendant number 2 is the bank, Your Lordship, and we do not have anything else. We just have the bank guarantee, Your Lordship.
Who is for the one?
As much.
Who is for the one? Kalyan Kumar Chakravarti?
Yes. Well, this is my notice, Milord, given yesterday, Milord, that I will mention.
So what do you want?
Well, I want closing, Milord. Kindly put it up, Milord, for the final.
Closing other side is not here.
Well,
Record or not.
This is not Milord, my affidavit document is with you. Milord, kindly take it on record.
No. Keep with you. Keep with you. We have 185. Where you keep? And the matter is listed as item number 185. Full stop. Land counsel for the petition mention the matter. Plaintiff mention the matter and submitted the interim order still today. The plaintiff has also drawn the attention of this court to the order dated 10th of June 2026, wherein this court directed the parties to complete the discovery and inspection of the documents within a period of 2 weeks. He submitted that though the plaintiff has offered the document to the defendant, but the defendants they have completed the inspection.
No. They have
but
said
the
that
defendants
I will take some more time.
But the defendants are neither come forward for inspection of the document of the plaintiff, nor the defendants have disclosed their document to the plaintiff for inspection. Full stop. In view of the submission made by the counsel for the plaintiff, for the interest of justice, one more chance is granted to the defendant to disclose their document and to inspect the document of the plaintiff within a week from date and to disclose their document within a week from date. And if the defendant disclose their document within a week, the plaintiff liberty to inspect the said document within a week thereafter. It is made clear that with the above period, if the defendants fail to disclose and inspection the document, the chance for discovery and inspection of the document on behalf of the defendants will be closed.
Kindly switch it to framing of issues, Milord.
Let the matter appear on 26th of August 2026 under the heading framing of issues. Interim order extended till 20th August 2026 or until further.
Document.
Next. Yes.
Not mentioning.
Milord, item 1. Milord, I appear for the appellant. Milord, your lordship had said today was for date fixing, Milord. Mr.
We had
Banerjee is on the
mentioned
other
it yesterday, my lord, yes.
Mr. Banerjee is leading me. He's logged
We are for the, I'm for the respondent, my lord.
for the
I'm for the
respondent.
respondent, my lord.
Yes. Acha, wax poll.
Yes, Your
Wax poll, my lord, wax poll, my lord.
Any date and time could be fixed, Your Lordship, as per your opinion.
Any date and time.
की डेट हो गई 3rd September. The matter is listed
4th September.
3rd September.
3rd September. Very well, my lord. 3rd.
Very well, third, my lord, third. Let it start, my lord.
Great.
The matter is listed as to be mentioned for fixing the date of hearing. Accordingly, let the matter appear on 3rd September at 3 p.m.
Grateful.
Very grateful, man. Very grateful.
Yes.
Item number 2, my lord, I appear for the respondent bank online. My lord, I appear for the petitioner, my lord. Am I audible to your lordship, my lord?
Yes.
My lord, kindly comes to, my lord, page 46 of the petition. My lord, the question is very, my lord, simple. Whether, my lord, the invocation of guarantee in the year 2025, after having invoked, my lord, taking steps, my lord, in 2014, is barred by limitation or not. Invocation of guarantee so as to, my lord, proceed against this person, the petitioner, under section 95 of the Insolvency and Bankruptcy Code. And I am, my lord, we are, my lord, we have been granted an interim relief, which was, my lord, challenged before the, my lord, division bench. Division bench, my lord, felt that since they have filed an affidavit in the form of a report, and now pleadings are complete, it should be heard by your lordship. This is the position. No, my lord, one small correction before my learned senior friend continues. The division bench on the last occasion had directed that prior to taking up the matter, my lord, or prior to extending the interim order, the point of maintainability be heard first. So they had not mentioned the matter with the division bench's order. That is an order, my lord, that is dated 12th of May 2026. Where the division bench, my lord, directed that let the point of maintainability be decided first prior to any extension being granted. Even though there is one extension that has been granted on the last occasion, because the matter could not be taken up, I did not oppose it. Division bench order, if lordship doesn't have it. My lord, kindly comes to internal page 3 of the my lord order. It's the last sentence. Under such last paragraph, my lord, under such circumstances, appeal and application are disposed of with a direction upon learned single judge to proceed independently on the issues raised by the parties. The maintainability of the writ petition shall be decided first. Learned single judge is decided to hear out the matter before expiry of the extended interim order. The business of the court that day did not permit. So if my learned friend is correct, I stand corrected, my lord. If he wants to address on maintainability,
yes, what is the
he has the first right, my lord.
What is the point of maintainability?
My lord, what they have challenged is, my lord, a pre-notice under the Insolvency and Bankruptcy Code that precedes the section 95 proceeding. Under the Insolvency and Bankruptcy Code, I'll show the provisions. It's a code by itself. What they have done to interdict that process, which they have now managed to do by getting the interim order, is they have stalled the entire proceeding before the NCLT. There was a notice, my lord, that I had issued. My learned senior friend's only contention is that the notice is barred by limitation. I am covered by your lordship's judgment in Sanjay Jhunjhunwala as well as two other judgments of the Honorable Supreme Court, which says that because the Insolvency and Bankruptcy Code is a code by itself, where the entire point, my lord, with respect to the report being filed by the resolution professional, it's a step-by-step process which is given. So therefore, the writ court will not intervene. My only point is this: I will not argue anything beyond this. I will show only 4 judgments, one your lordship, 2 Supreme Court, and 1 Kerala High Court.
Where is the notice?
My lord, 46.
Yes.
Kindly comes to page 46. In fact, 2 notices. One is at 41, the other is at 46. The notice they've challenged I'm sorry, my lord. The notice they've challenged is page number 67 of the writ petition. Prior to that, 46, my learned senior friend is right, is the first notice that was issued in the year 2014, which was for invocation of guarantee.
because admittedly the petitioner is a guarantor to the loan. The company who was the original borrower, now that company has gone into CIR. 46, my lord.
Yes.
46 is, my lord, dated 24th of February 2014. My learned senior friend is absolutely correct. My lord, after that, on 11th of January 2022, the borrower company goes into CIR, which is at page number 55 of the writ petition. Thereafter, my lord, we issue a notice under section 7, subsection 1 of the Insolvency and Bankruptcy Code. Lordship will kindly, my lord, take up page number 67.
No, page 55, who has filed the application under 7? Punjab
A
National Bank.
separate bank, my lord, a separate bank. I am not involved in that proceeding, even though I am a part of the COC. It's not been filed by me. That's by Punjab National Bank.
Yes.
My lord, after that, the first notice, my lord, is issued under 7.1 on 9th of February, which is at page number 67.
Yes.
Well, that is the notice that I issue, my lord, in terms of the Insolvency and Bankruptcy Code, followed by, my lord, an invocation of personal guarantee. That is dated 15th of May 25. That is at page number 73. And a subsequent, my lord, notice under section 7.1, which is at page number 81. This is the last document I have to show. Page number 81 is the 7.1 notice. 11th of June 2025. Yeah. Page 81.
Yes.
This is the last notice that I invoke, my lord, but this is a prerequisite under section 95 of the Insolvency and Bankruptcy Code. Now, the writ petitioners challenge the notices which are appearing at page number 73 and 81. And their only contention is because the invocation of the guarantee had originally taken place in 2014 and the respondent bank did not take any steps for recovery of the money. Therefore, these two invocations are barred by limitation. That is their only case in the writ petition. Now, when they challenge this by an order, my lord, dated, I'll just passed by the coordinate bench on 20th of August 2025 by Justice Sinha, the entire recovery proceeding gets stayed on the point that this is ex facie barred by limit, not on the point that it's ex facie barred, but because there's a triable issue and this is barred by limitation. Well, my contention is onefold. I will not make any further submission. I'm not even going to submit on merits. My only point, Millard, is that the notice under section 7.1 of the IBC, that is a mandatory statutory prerequisite prior to filing the section 95 proceeding. Now, once I file the section 95 proceeding under the IBC, I'll show 3 sections, but before that, I'll just quickly orally preface my submission. When the 95 proceeding is filed, there is an incumbent direction upon the NCLT to appoint a resolution professional. The resolution professional will file a report before the NCLT to see whether it is a fit case for the the 95 proceeding to be allowed or not allowed. Now, once that report comes in, the adjudicating authority, which is the NCLT, will return a finding. If it is seen that it's a fit case for recovery, it will go on with the case. If not, the proceeding will be dropped. Now, the Insolvency Bankruptcy Code 2016 is a code by itself. Now, once there is a proceeding which has been commenced under the Insolvency and Bankruptcy Code, the writ court will not interfere and then stall the proceeding, or the Supreme Court uses the term also quoted by your Lordship in Sanjay Jhunjhunwala, the writ court will not interdict the proceeding because the petitioner or the writ petitioner has ample opportunity under the court to take up all these points, including the point of limitation. This is the long and short of my submission, Manoj, that the writ court will not interfere into the proceeding, whether it's barred by limitation, whether it's not barred by limitation. These are all mixed questions of fact and law that the writ court will not enter into. Lordship allows me to place, Malad, one judgment. I'll directly come to the judgment. I don't think, Malad, this requires further wasting of my lord's time. Lordship will kindly, Malad, take my learned senior friend is there. Malad, Bank of Baroda versus Farooq Ali Khan. This is, Malad, 2025 STC Online, Supreme Court 374.
You are appealing for respond number?
My lord, I am appearing for the respondent bank, my lord, all of them. Canara Bank. If your lordship, my lord, kindly takes up.
Okay, paragraph?
Yes. My lord, I'll start with paragraph 2. The question for our consideration is whether the High Court could have justifiably invoked judicial review under Article 226 of the Constitution to interdict personal insolvency proceedings initiated against respondent number 1 under Section 95 of the IBC by holding that his liability as a debtor had been waived. The High Court jurisdiction was invoked against the order of the adjudicating authority dated February 16, 2024, appointing a resolution professional and directing him to examine the application under Section 95 and file a report under Section 99 of the IBC. Now, my lord, kindly, my lord, directly comes to paragraph 11. Well, everything in between is, my lord, the submissions. I'll not, my lord, trouble your lordship with it. Paragraph 11 at page number 4. It is well settled that when a statutory tribunals are constituted to adjudicate and determine certain questions of law and fact, the high courts do not substitute themselves as the decision-making authority while exercising judicial review. In the present case, the proceedings had not even reached the stage where the adjudicating authority was required to make such determination. Rather, the High Court exercised jurisdiction even prior to submission of the resolution professional's report, thereby precluding the adjudicating authority from performing its adjudicatory function under the IBC. Now, paragraph 12. While there is no exclusion of power of judicial review of the High Courts and the limits and restraint that the Constitutional Court exercises and must exercise are well articulated, the primary issue involved in the present case, including the factual determination of whether the debt exists, is part of the statutory and regulatory regime of the IBC. In fact, the entire rationale behind appointing a resolution professional under Section 97 is to facilitate the determination by the adjudicating authority. The High Court ought not to have interdicted the proceedings under the statute and assumed what it did while exercising jurisdiction under Article 226 of the Constitution. In this view of the matter, we are of the opinion that the High Court was not justified in allowing respondent number 1 writ petition. The High Court should have permitted the statutory process through the resolution professional and the adjudicating authority to take its course. Now, my lord, paragraph 13, there's a portion which is quoted. I'll show it separately also, my lord. The High Court should have noted that insolvency and bankruptcy code is a complete code in itself, having sufficient checks and balances, remedial avenues and appeals, adherence of protocols and procedure, maintains legal discipline, and preserves the balance between the need for orders and the quest for justice. The supervisory and judicial review powers vested in the High Courts represent critical constitutional safeguards, yet their exercise demands rigorous scrutiny and judicious application. This is certainly not a case for the High Court to interdict corporate insolvency resolution process proceeding under the IBC. In view of the above, the impugned order is set aside. But in the case I've relied upon, the case was admitted and the RP was appointed. In my case at hand, the case has not even been admitted, only a demand notice has been issued. So I am coming, my lord, even at a stage prior to the proceeding which is there in this judgment. Now, my lord, directly I'll come to my lord Sanjay Junjunwala, rendered by your lordship.
Whether you initiated the proceeding under 95?
No, my lord, I could not because I've been stayed by the High Court. I have issued a demand. Now, if your lordship looks...
My learned friend stands corrected. The application has been filed and there is a stay on that proceeding. Your lordship.
Which one?
On the Section 95 proceeding.
It's filed?
Yes.
It is filed. It has been stayed by this Honorable Court. By a previous order, your lordship.
By a coordinate bench, my lord. This is 20th of August. I stand corrected, my lord.
The
coordinate bench in the same case.
Coordinate bench, okay, no problem.
By your lordship, in the same matter. The matter was at that point in time being heard by a different different bench, my lord. 20th of August 2025.
Okay. So now your application is pending.
Yes, your lordship.
Yes.
Now may I show the Sanjay Junjunwala judgment? Lordship takes into account, my lord, the judgment that I've already relied upon.
Yes.
Lordship looks at paragraph 9, my lord, first. This is just to, my lord, give a preface of the facts.
Yes.
Paragraph 9, my lord, Mr. Bose submits that on 15 July 2025 and on 16 July 2025, proceedings under Section 95 of the IBC was filed. The nature of the proceedings under Section 95 of the IBC has now received judicial interpretation. The proceedings under Section 7 are instituted against the corporate debtor, which falls under Part 2 of the IBC. The proceedings against the guarantors who are individuals can only be filed under Section 95 of the IBC, which falls under Part 3. Now, my lord, directly, my lord, comes to, my lord, paragraph 19 once at page number 7. I'm not separately, my lord, showing this judgment, which is why it's quoted here. So I'm just going to take your lordship through this itself. Paragraph 19.
Yes.
In the case of Dilip B. Jivrajka versus Union of India, the Honorable Supreme Court held that in a batch of 384 petitions under Article 32 of the Constitution, the petitioners challenged the constitutional validity of Section 95 to 100 of the Insolvency
Page.
At page number 7.
7. Page 7.
One.
Yes.
Well, in this case, the constitutional validity of Section 95 was upheld by the Supreme Court. But I don't want to unnecessarily show, but basically, says that Section 95 is otherwise constitutional. So there's an entire procedure which has been laid down. My lord may directly look at paragraph 20 onwards. I'm sorry, paragraph 83. I'm very sorry, paragraph 83, page 11.
Yes.
Before concluding, it would be necessary to deal with two incidental submissions which were heard during the course of hearing. It is sought to be urged that subsection 2 of Section 95 indicates an application under Section 1 can be initiated only in respect of a partnership debt which is owed to the creditor. We are of the view that this is not a correct reading of Section 95. Subsection 1 indicates that a creditor may apply either by themselves or jointly with other creditors or through a resolution professional to the adjudicating authority for initiating an IRP. Subsection 2 provides that in a situation where a creditor has applied under subsection 1 in relation to a partnership debt, the application may be filed against A, any one or more partners of the firm, or B, the provisions of subsection 2, in other words, cannot control the ambit of subsection 1 of 95. The Honorable Supreme Court held that the adjudicating function of the adjudicating authority commences under Part 3 of the IBC after the submission of a recommendatory report to the resolution profession. The clear difference between CRP under Part 2 and insolvency resolution process for individuals and partners under Part 3. The legislature has carefully calibrated the role of the resolution professional, the imposition of the moratorium, and the stage at which the adjudicating authority steps under Part 2 on one hand and Part 3 on the other hand. It is further held that this is based on an intelligible differential between the nature of the insolvency resolution process in the case of corporate debtor on one hand and individuals and partners. Then, my lord, Bank of Baroda versus Farooq Ali has been quoted in this. My lord, directly comes to now, my lord, paragraph 23, which is quoted inside. That is at page number 14. It is quoted within the judgment.
Yes.
There is no dispute that proceedings under Section 95 is initiated against the petitioner. It is well settled that when statutory tribunals are constituted to adjudicate and determine certain questions of law and fact, the High Court do not substitute themselves as the decision-making authority while exercising judicial review. In the present case, the proceeding has not even reached the stage where the adjudicating authority was required to make such determination. The petitioners have an opportunity to raise all the issues before the adjudicating authority. Moreover, before the appellate court, the learned counsel for the petitioner number 3 submits that his client does not object to the National Company Law Tribunal deciding upon the application under Section 7 of the IBC in accordance with law. The appellate court in its order dated 3rd November 2025 clarified that the legality, validity, and sufficiency of recall of notice and follow-up notices may be decided by the NCLT. Now, my lord, 27 is where my lord is pleased to, my lord, dismiss the writ petition. 27 is the final, my lord, finding that because the NCLT has, my lord, the entire, it's a court by itself, but the IBC is a court by itself, the NCLT has all the checks and balances in place to adjudicate all questions of fact, which is basically the question that they've raised here.
Yes.
Now, my lord, one other judgment. This is, my lord, Mohammed Enterprises versus Farooq Ali Khan. I'll only show, my lord, paragraph 9 and 15.
Paragraph
9 and 15, man. 9 is the submission that gets upheld at paragraph 15. Lordship kindly takes up 9 points. Mr. So-and-so learned Solicitor General supported Dr. Singhvi's submission and objected to the High Court exercising jurisdiction under Article 226, interdicting proceedings under the court. He referred to the decision of the court in Committee of Creditors in so-and-so judgment, taking exception to the High Court exercising its discretionary jurisdiction under Article 226 of the Constitution, breaching the discipline of alternative remedy as contemplated under the IBC. Now, paragraph 15.
Yes.
Paragraph 15, my lord.
Yes, go on.
Apart from the delay and laches, oh, very well. So that is what I wanted to show. Only on the point of the jurisdictional issue, my lord, there's one Kerala High Court judgment. Also in the case of NCLT, my lord, Arun Matthew judgment. So this, my lord, I deeply apologize. I could not, my lord, get the SCC copy. I downloaded it from the server of the High Court.
Yes.
This, my lord, will kindly take up, my lord, paragraph, page number 23 of this order. Judgment. Because the paragraph numbers are not there in every page I'm referring to it. My lord, page number 23.
Yes.
Well, it's the 7th line from the top starts with petitioner relies on the judgment. In Embassy Property Development's case cited Supra, which consider the jurisdiction and power of the High Court under Article 226 of the Constitution of India, where there is an alternative remedy provided to challenge the said order, and in the said judgment it was held that an exception to the self-imposed restraint of the High Court when the statutory alternative remedy of appeal is available is a lack of jurisdiction on the part of the statutory quasi-judicial authority against whose order a judicial review is sought, and held that the distinction between the lack of jurisdiction and wrongful exercise of the available jurisdiction should certainly be taken into account by the High Court when Article 226 of the Constitution is sought to be invoked, bypassing a statutory alternative remedy provided under a special statute. So going by the said judgment, when there is a lack of jurisdiction of the tribunal to entertain a petition, naturally the petition is entitled to invoke the jurisdiction of the High Court under Article 226 of the Constitution. But when it is a case of wrongful exercise of available jurisdiction, the party should be relegated to challenge the proceedings before the statutory appellate forum. Therefore, this court assumes jurisdiction in a case where the NCLT has absolutely no jurisdiction to entertain so-and-so company petition and to issue order. The specific contention raised by the petitioner is also on the said line. Therefore, the court has to consider as to whether the NCLT has jurisdiction to consider company petition and to issue order. The learned counsel for the petitioner will rely on that judgment. If your lordship just comes at the bottom of page 25.
Yes.
In this case, the apex court was essentially considering the question as to whether the NCLT has power to issue directions in relation to matters covered by the Mines and Minerals Act. And the court held that the matter which is in the realm of public law is not within the jurisdiction of the NCLT. And the proper forum of adjudication of public law claims is the writ jurisdiction of the High Court. And therefore, the orders of the NCLT was interfered with. In embassy property case cited Supra, the court was dealing with a totally different issue. I am of the view that observations in paragraph 33 and 34 of embassy property development case cited Supra, which is extracted above, will not come to the help of the petitioner. In the said judgment, the court has examined the powers of the NCLT under section 60 of the Insolvency and Bankruptcy Code, and interpreting the various subsections of section 60 of the code, has held that where CRP or liquidation proceedings of such corporate debt is already pending before the NCLT, the proceedings against the personal guarantor of a corporate debtor is also to be taken up before the NCLT concerned, so that a single forum may deal with both as to ensure that the CRP of a corporate debtor and the insolvency resolution of the individual guarantor of the very same corporate debtor do not proceed on different tracks before different fora, leading to conflict of interest, situations, and decisions. Therefore, it is held that the object of subsection 2 of section 60 of the code is to ensure that both the proceedings are dealt with together. The court also looked into section 179 is not relevant. My lord may only refer to page number 28, but that's also settled proposition. This I don't have to, my lord, show. But the writ petition was dismissed, my lord, at page number 39 and 40. I'm already, I can see the clock, my lord, from the view. It's already, my lord, I'm past by 10 minutes. Well, these are my respectful submissions. The only contention is that it's barred by limitation. Now, whether it is or not, my lord, I'm not going to pass a comment. That is for the NCLT to decide. These are my respectful submissions.
Yes. My lord wants to hear it today.
Come next. Land Counsel for the respondent bank has argued the matter on point of maintainability. Due to paucity of time, Land Counsel for the petitioner to argue the matter. Case is adjourned. Let the matter appear on Monday.
My lord, may I only pray, my lord, Tuesday, my lord, instead of Monday?
Tuesday.
Tuesday. Grateful. My lord, the interim order is still today.
Interim order is extended till the next date of the
Yes. My lord, if it retains its position, we can conclude it because I have, my lord, authorities to cite, my lord, that on the issue of limitation armed by Calcutta High Court, affirmed up to my lord Supreme Court.
3 p.m. to fix.
My lord.
If you want to fix, then it will go.
No, I don't want. I know, my lord, the pressure, my lord, of this court, my lord. If it appears fairly at the top, we know it would be taken up. My lord, I don't. Grateful.
Court matters no power.
Grateful, my lord.
I'm most grateful to your lordship.
Matter of appeared at our instance, considering the urgency, my lord, please to keep. My lord, maybe that item 6, my lord, kindly allow it to appear on Wednesday instead of Monday and Tuesday due to some professional reason. I must be our Abdar.
As per the prayer made by the counsel for the
And my lord,
let the matter appear on 29th.
then I may make one request if your lordship, fairly at the top, my lord, if you, my lord, because the 2 days, my lord, we are here, my lord.
Yes, next.
My lord, deeply obliged. Okay, naam de dichi. Deeply obliged. We will communicate the other